Right after the quiz, do you have another week break or
No,
you're
right after
continuing the exams?
after the quiz, we are starting our exams.
The next weekend.
Yes, please.
All right. Okay. So today we'll be doing our last two topics and then we'll be done.
We are doing our quiz on 11th and 12th April.
11th and 12th April, rather.
Yes, according to the timetable I have.
All right. So 11th and 12th, you have your quiz, and then the exams will start on the
18th to 26th.
right. Okay. All right. So let's start. The call is being recorded. Whilst you also prompt your colleagues that the class has started so that they can join along the way. So
Yes.
after we finish today, I will be giving you some tutorial sets. As I've already mentioned, they are just compiled past questions. They are just compiled past questions. Now, as we are here, I know we know how to answer what is explain, describe, those kind of things. Those kind of things are quite simple. So if you're able to read, you'll be able to answer those questions. But there are some case studies in business law that we have to know how to answer them so that we'll be able to get an understanding on how to tackle these case studies. So we'll discuss this after the class, whether we should have 1 hour to continue or 1 hour at a different time to learn how to solve these questions. All right. So today we'll be doing thoughts. We'll be doing thoughts and sale of goods. We'll be doing thoughts and sale of goods. Now, the idea of thought is when someone wrongs you. When someone wrongs you. Generally, people wrong us when we have a relationship or a contract with them. Generally, when you see some of these suits that people sue you, you see that you have a contract, you've breached it, you should have done something, and you didn't do it. So usually, we've seen those kind of suits. But when it comes to thoughts, thought necessarily doesn't look at the contract or relationship that you have with someone. The fact that you've injured someone, the fact that you've hurt someone entitles the person for some form of compensation. So you don't have to have it in mind that you need to have a contract with someone before the person can sue you. No. Even if you don't have a contract with someone, or even if you don't have an agreement with someone, and the person injures you or the person hurts you, you have the avenue of suing the person. So that is the general idea of thoughts. That is a general idea of thoughts. It is usually given private remedies. Usually, thoughts can give private remedies. But sometimes you can perform an action, and that action can yield both private remedies and criminal prosecution. So you can do something, and the thing that you would do can yield both private and criminal actions. When you beat someone up, the person can get private compensation. And when the person reports it to the police station, they can also take it up for criminal prosecution. So you can have one action leading to both private and then the criminal actions. All right, so let's look at thoughts and look at the types of thoughts. Now, there are a lot of types of thoughts. There are a lot, but we'll just be limiting ourselves to a few. We'll just be limiting ourselves to a few. I will list the examples that we have, and if you want, you can go and read more on them to help you. But as business students, just this few might help us navigate how we go through our business lives. So, the idea of thoughts. Now, thoughts come from Latin origin. It means, or it comes from the Latin word tortus, which means twisted or crooked. Now, in French, the French word for thought is wrong. So when someone wrongs you, you get a remedy. Now, it has been used to describe any wrongful acts other than a breach of contract, for which relief may be obtained in the form of damages and injunctions. So someone hurts you, generally you can get damages, you can get injunctions from them as a relief. Now, tort involves private wrongs, which is different from criminal actions, which are public wrongs. So these are just private remedies. Like I said, so it can be only one act, and that act can lead to both private and public wrongs. However, with the private wrongs, the person himself is going to sue you to get compensation for himself. And then when it comes to public wrongs, the government can take over and prosecute the person and punish the person. So you can have someone satisfying you privately and also being punished by the government. Like the earlier example that I gave, when someone beats you up, can report a person for criminal prosecutions. That doesn't mean that when you go to hospital and the hospital gives you a bill, the person doesn't have to take up those bills. So you can sue the person for private wrongs to recover for your medical bills and other injuries that you've gone through, whilst the government or the state also continues with their criminal prosecutions. So they can differ. However, sometimes they can be together as a case. So they can be together or they can both arise from one action. We are saying that you can get your private compensation while the state also prosecute the person publicly. But with tort, we are looking at the private wrongs that a person has done and also how you can get your remedy. Now, tort serves two main notions. One, wrongs and also compensation. Remember, equity will not suffer a wrong or equity will not suffer an injury without a remedy. So where there is a wrong, there's a remedy. Where there's a wrong, there's a remedy. So here too, when someone wrongs you, when someone injures you, you have an avenue to also get compensation from the person. So in a tort action, one person or a group of persons could bring a personal suit against another to obtain compensation or relief for a harm suffered. So the purpose of tort law is to provide remedies for the invasion of various interests. So you invade my interest or you harm me, have the avenue to sue you. This is because people cannot just go around harming people. You just go around harming people and get away scot-free. So this tort is there to make sure that usually when you harm people, there should be an avenue for the person to be compensated. So we have categories of civil actions that constitute a tort. These are categories. And now these categories can be split into intentional and unintentional. Intentional and unintentional. Now, with the intentional ones, we are saying this is where you intentionally hurt somebody. So when you intentionally hurt somebody, you have an intentional thought. That means that you did it with the intention. Yeah, you had the intention that you were going to hurt the person. That leads to intentional thought. So, for example, you have assault and battery. Assault and battery. We also have trespassing. We have defamation. Now, assault is where you cause harm to someone without striking the person. So you cause harm to someone without striking the person. So if you make someone shiver just because you threw a punch, but the punch doesn't hit the person, that can constitute an assault. So this is where you cause emotional, psychological pain to someone just because, or you cause emotional and psychological pain to someone without touching the person, then you have assault. But with battery, this is where you have physical contact with somebody. With battery, you have physical contact with somebody. So when you punch somebody, when you hit somebody, that constitutes battery. So you've been hearing assault and battery. Assault, there is no contact. But with battery, there is contact. Also, we have trespass. That is why you cannot just walk into someone's home just like that and go and sit there and watch television. You cannot walk into someone's property and just do whatever you want on the person's property. So that is what trespassing. That one is done intentionally. When you walk to someone purposefully, that is intentional thoughts. And then we have defamation. We're breaking defamation down. But at this point, the idea of defamation is when you spread false information to tarnish someone's image. You do that on purpose. When you are spreading false information to tarnish someone's image, you know that the information you are spreading is false. So that is done intentionally. And then the unintentional ones could be the negligence. Now, with negligence, this is where you cause injury to somebody just because you owe the person a duty of care. Also, we will be breaking down negligence. But one thing you should know about negligence is that here there is something called the neighbor principle. The neighbor principle, where if you do something to hurt your neighbor, the court will presume that you owe a duty of care to your neighbor. You owe a duty of care to your neighbor. And if you owe a duty of care to your neighbor and you breach it, the neighbor can sue you for negligence. That means that there's something that you should have done, or there's something that you omitted to do that has caused your neighbor harm. Now, when we are looking at the idea of neighbor, it comes from the idea that someone living next to you or proximate to you is your neighbor. But the law has also stretched the definition of neighbor to mean that anyone whose actions or anyone who your action could affect could essentially be your neighbor. So neighbor, so when you look at neighbor, neighbor can be someone who is proximate to you, or even if the person is very far away from you, but the person's actions could affect you, that person can be construed as your neighbor. So if you are doing something, you should be very careful. Proximity alone doesn't constitute neighborhood. Proximity can constitute neighborhood. However, even if the person is farther from you and your actions could affect the person, that person could be construed as your neighbor, and you would owe that person a duty of care. And if you owe the person a duty of care and you breach it, the person can sue you for negligence. And then we have strict liability thoughts. With this strict liability, we are looking at it from a perspective where the person wasn't negligent. That means that the person did everything right, but something still went wrong and you got hurt. So the person took reasonable steps to make sure that every single thing that they are doing goes right, but something goes wrong and you get hurt. The fact that they did everything right and you still got hurt doesn't mean they can go scot-free. So with strict liability, we are looking at the fact that the moment that you get hurt, you can sue the person, and you do not need to prove fault or intent. So you do not need to prove that the person was at fault or the person did it on purpose. Just the fact that the come to you, you can sue the person. So this applies to when you are engaging in inherently dangerous activities or dealing with defective products. Sometimes there are production lines that they will do every single thing to make sure that the product comes out better. They will do every single thing to make sure that the product comes out better. However, one product may be defective and may cause harm to somebody. The fact that you did everything right doesn't mean that someone is hurt and then you can just go scot-free. No. So that is what the strict liability. Yeah, they apply their liability strictly. The fact that you did everything right doesn't mean you should get to go scot-free. If there's a defective product coming from you, even if you didn't do anything wrong or you didn't intentionally do something, or there is no fault of yours, the person can still sue you. So, like as I already said, this classification is particularly of a particular thought depends on whether it was done intentionally and also the surrounding circumstances. So let's look at some points to note when it comes to intentional thoughts. So an intentional thought requires only that the thought fixer or the actor or the wrongdoer. So in thought, when you see a thought fixer, that is the one who is what? Inflicting the injury. So the thought fixer, the actor, the wrongdoer, they are used interchangeably. So intended or knew with substantial certainty that the consequences would result from his actions. So intentional means that you that one you intended to do that thing to the person, or even if you didn't do that, also you knew with substantial certainty that with what you are doing, it will cause the person this harm. You can't tell me that you don't know that when you hit someone, the person will get hurt. And because you didn't do it intentionally, that shouldn't be intentional. No. If you intended to, that is one. Or you should have known that when you hit someone, the person can get injured. That all constitutes intentions. So an intentional thought requires intent. That means you did it on purpose. Now, intent does not necessarily mean that the actor intended to harm someone. Rather, it means that the actor intended that the consequences of his act, or he knew the consequences of his act. So, with intention, we are looking at three things. One, you actually intended to do the thing. You actually made up your mind that you're going to do that thing. That is one. Two, you know the consequences of your actions. Or three, you know with certain certain certainty of the certain consequence that will result from your act. So if you know the consequences of your actions, you cannot say that you didn't intend to hit the person. Even if you didn't make up your mind that you're going to hit someone, the moment you know that hitting someone is going to hurt the person, when you hit the person, it's going to imply that's what you intended to hit the person. And that is what an intentional does. So let's distinguish assault from battery. I've already distinguished it, even though we are not going to go down assault and battery. Let's distinguish it. Now, assault is an intentional thought that causes another person to reasonably fear immediate or harmful or offensive contact. So with assault, there is no contact, but you do something to make the person feel like there's an imminent or the person can be struck at any time. Like I've already said, when you know pretend like you're going to punch someone, but you don't actually punch the person, that is assault. When you say words that cause the person to psychologically think that there is what an immediate contact or there's a harmful contact coming to the person, that is assault. But with the battery, this is where you what physically touch the person. Now with assault, usually it is described loosely as when you touch someone without the person's consent. When you touch someone or you hit someone without the person's consent. So that means that when you agree that I should hit you and I punch you, that is not battery. When you agree that I should hit you or I should punch you, that is not battery. But if there is no consent and I punch you, that is the battery. So with the what that's what physical contact without any permission or without any consent. Now, this physical contact, generally it is what harmful and what offensive in this physical contact. Then you have what a battery. So you've been hearing assault and battery. There's a difference between assault and what battery. Assault, there's no physical contact, but with battery, there's physical contact. Now, aims of common law thoughts. When you see someone, or common law thoughts were developed because to satisfy these aims that we have. One, appeasement. Tort law provides a legal avenue for victims to seek redress, thereby claiming emotions, preventing private revenge, and also restoring social harmony between the parties. So it is meant to appease the party who has been wronged. At least the person gets some sort of satisfaction. Otherwise, where the person would have taken matters into his or her own hands and go and seek for revenge, the person knows that when he goes to court, there is some level of compensation to appease the person. So the person is going to go to court. So we have justice. With justice, we are saying that it ensures fairness by holding the wrongdoer accountable, whilst recognizing and vindicating the rights of the injured party through legal means. Also, we have deterrence. The idea of deterrence is to stop you or to stop another person from doing what has been done. So, tort law discourages both the defendant and the public from engaging in harmful conduct by imposing legal consequences. So, they do this to deter people, they do this to stop people from repeating that act. And lastly, we have compensation to financially restore the victim to as far as money can to the original position before the harm. So with compensation, you go to court, someone has done harm to either you, your reputation, or anyone. They give you some money as what compensation in order to what restore you to where you were before the person did it. Now this one, it is as far as money can. So they give you money. So that's why when, let's say, someone beats you up and you go to the hospital, they give you money for the bills and maybe some lost revenue that you could have got from your employment. They add all together and they give those things to you. When they give those things to you, it is to compensate you or to put you as far as money can to where you were before the harm was suffered by you. Now let's do negligence. Here we'll be doing negligence, we'll be doing product liability, and we'll also be doing defamation. That is our three main things that we'll be looking at. We're looking at negligence, We'll be looking at product liability, and then we'll be looking at defamation. Now, negligence, as I've already duty of care to be owed, and then you breach that duty of care, and then someone suffers a damage as a result of the breach that you've that as a result of the breach, and then we have negligence. So negligence is defined in the 17th edition of Winford and Delowitz on tort as a breach of a legal duty to take care which results in damage to the claimant. So in Alasan Kotokoli versus Moro Musa, Edusai J spoke about negligence as follows. Now, negligence means more than heedlessly or careless conduct. It probably connotes the complex duty of complex concept of duty, breach and damage thereby suffered by a person whom the duty was owed. In Blight versus Birmingham Waterworks, negligence was defined as one, the omission to do something which a reasonable man would have done, guided upon those considerations which ordinarily regulates the conduct of human affairs, would do, or doing something which is prudent and a reasonable man would not do. So this is what with negligence, we're looking at something that a reasonable person would have done, or a reasonable person would have done. So if you do something that a reasonable person wouldn't have done, and you hurt someone, that is negligence. So with negligence, you're looking at the fact that you owe that person a duty of care, even though those duty of care is not expressly written down. You cannot just go around hurting people just because you say there's no duty of care. So a duty of care impliedly, when you are living with someone or you're living close to someone, there are certain things that you should not do in order to cause harm to the person or to cause harm to the person's property. Or there are certain things that you could do, and when you do, it is not going to cause harm to those people. If you fail to do that, that is negligence. You are in your room, you are playing with fire, you are playing with matches, you are playing with lighter. When you burn someone's house down, the person can sue you for negligence. The fact that the person is your neighbor doesn't mean that it what, the fact that I don't have a written contract not to burn the person's things down doesn't mean that they are going to go scot-free. So negligence is not actionable per se. This means that you must prove actual damage. So you cannot sue someone for negligence and then they will just award you your compensation. So actionable per se, it is very important when it comes to law. When something happens and they say it is actionable per se, that means that all you need to do is to make sure that the person did it. If the person did what you are accusing the person of, then you can just win based on that. But if it is not actionable per se, you must prove that what the person did has caused you harm. So if you cannot prove that what the person did has caused you harm, then you cannot win the case. So when it comes to negligence, we are saying it is not actionable per se. Negligence is not actionable per se. That means that you have to prove that what the person did has caused you an injury. What the person did has caused you harm. And if you are able to prove that, then you can win the case. Just proving that the person did it doesn't mean you've won the case. The person could have done it, yes. However, if you cannot prove the damage or you cannot prove the injury that has been caused, you're not going to win on a negligence suit. That's what we say when we mean by negligence is not actionable per se. Negligence is not actionable per se. So elements under negligence. What you need to prove under negligence. Usually there are three elements. We have duty of care, we have breach of those duty, and then we have damage. Some people can split it into four. The third point, some people split it into four. When you get there, I'll show you. But all you need to know is that these elements must appear. We have duty of care, we have breach of that duty, and then we have damage. That is the loss that has been caused. So when it comes to duty of care, in Donahue versus Stevenson, Lord Atkin explained neighbor as someone who is closely or directly affected by any act that I ought to reasonable to have had them in contemplation as them being affected. So whether the person is close to you, or even if the person is far away from you, if your actions could affect those people could be your neighbor. So you realize that when we go down, some examples will show that if someone is manufacturing a product and the person should have taken reasonable care to make sure that the product is safe, and the product is not safe and you consume and you get hurt, you can sue that person. So in Ghana here, let's say the Coca-Cola company is somewhere in Accra, you're in Kumasi. If you take Coca-Cola and there's something in it and that thing causes you to get hurt, I shouldn't even mention a known brand, but let's say you take a drink and the drink is in Accra, and then when they were bottling the drink, they didn't do something right, and then you take the drink and you get hurt. When you take the drink and you get hurt, let's say you get a stomach upset, you can sue the Coca-Cola company. Now, even though the Coca-Cola company is not directly or is not proximately by your side, their actions in Accra has what hurt you. So if the actions in Accra, if the drinks company's actions in Accra has actually what hurt you, you can sue the person. So with neighbor principle, we are saying that distance shouldn't be a barrier to the neighbor principle. Now, an idea is that proximity can what mean neighborhood. However, even if it's not proximity and the person is far away from you and the person's actions can cause you harm, then we can still infer the neighbor principle. So even if you are far away from someone, but your actions can cause the person harm, you can what infer the neighbor principle, and the person can sue you. So thus, you must take reasonable care to avoid acts or omissions which you can reasonably foresee that will likely what injure your neighbor. So here we have what acts and omissions. Something you ought to have done, something you shouldn't have done. All of these things can constitute what breach of duty. We'll get there. But we are looking at it from the fact that something that you should have done or something that you ought not to have done, you shouldn't have done. So either actions or inactions could constitute or could contribute to this negligence. So in the later case of Caparo and then Denkham, they later added the what the foreseeability, proximity, and fairness principle. So proximity means that the parties must be sufficiently close so that it will be reasonable, what foreseeable, that one party's negligence would cause a loss or damage to the other. The last stage would be whether it is fair, just and reasonable for the court to find the defendants owed a duty of care to the claimant. So all of this is to determine whether you owe a duty of care or you didn't owe a duty of care. If you don't owe someone a duty of care and you don't do anything and the person gets hurt, the person cannot sue you. So the idea is that we need to establish that there was a legal duty of care owed by the person. And whilst we are establishing that, that is where we take out the neighbor principle to see. If you can establish that the person is your neighbor, then the person owes you a duty of care. That is the idea. And then when we are establishing whether someone is your neighbor, we're looking at the fact that whether the person is what proximate to you, whether the person is very close to you. That is one way of looking at it. But that's one way of finding out whether someone is your neighbor. Or even if the person is not close to you, the person is what? It is foreseeable that the person's actions or inactions can affect you. Like the drinks example that I gave. The drinks company is in Accra, you're in Kumasi. But if the drinks company doesn't do something right, they should have an idea that if they don't do something right and someone drinks it anywhere in the country, the person can get hurt. So they reasonably foreseeing that anyone who takes their drink can get hurt. We could also what infer the neighbor principle. So it could be from either proximity or also foreseeing that what you are doing could affect someone else. And then after we will see whether it is fair, just, and what reasonable to what imply what the neighbor principle. Whether if we don't say the person is your neighbor, whether it is going to be fair or unfair to you or the person. So that is what the idea of duty of care. So anytime we want to establish whether someone owes a duty of care, we go to whether the person is your neighbor or the person wasn't your neighbor. If the person is your neighbor, the person owes you a duty of care. If the person cannot be said to be your neighbor, the person doesn't owe you a duty of care. Now, I've already mentioned that neighbor isn't only what proximity. It can mean proximity, but it goes beyond proximity. Now we go to duty of care. Now, still on duty of care, we are looking at it from the perspective of liability for omissions. I remember I told you that when it comes to negligence, where we have both actions and omissions. Now, is someone liable if the person omits to help you? You are going your way, you see someone drowning. You see someone drowning in the river. If you pass by without doing anything, are you liable for negligence? So if you are passing by and then you don't do anything, are you liable for negligence? So we are looking at actions. With actions, that's something that you did. That one it can what be seen that okay, you did something wrong. But with omissions, it can be little bit was tricky. So we are looking at the instance where if you omit to do something, you can what be held liable. Because someone will say that I didn't do anything, it wasn't my place to do anything. So why are you suing me? So with omissions, it can be a little bit more tricky. That is why with omissions, we'll be looking at the instances where the person would be liable or the person wouldn't be liable. Because if you go around tagging someone that if the person doesn't do anything, the person is liable for you to pay the person money, then it might be a little bit what far. So we are going to establish whether the person is what liable for what omission or not liable for omission. Now the general principle is that when you omit to do something, there is no liability. I didn't do anything, so I shouldn't get what? I shouldn't be liable. That's the general principle. The general principle is that if you omit to do something, then you are not liable. However, there are certain exceptions to this rule. One, control. If you have control over that item, or if you have control over that situation, and you omit to do nothing, then you will be liable. So under these, we are saying that if you omit to do something, these are the situations where you will be held liable under negligence, and then you would infer duty of care. So one, if you have control over the situation. So control over the situation arises when a defendant has a high degree of control over the individual and thus is held to own a duty of care to exercise control responsibly. Now, in Reeves versus the Commissioner of Police, the police was held responsible after an suicide watch was able to kill himself. So if you are able to control the circumstances, if you're able to control the person and you do nothing, we are saying that omission can what? The omission can lead to what? Liability. Also, if you assume responsibility, so this situation involves, as might be expected, scenarios where one individual is implicitly by merit or what contract of employment. So if you intentionally take it that okay, I am responsible, then you'll be held responsible for liability. Or even if you don't do that, and it is by way of merit or by contract of employment, you would be held liable if you omit to do that. So, for example, we have Costello versus the chief constable of the Northumbria police station, where it was held that by merit of their joint employment, one had duty of care and had to act to what prevent foreseeable harm from occurring. And then lastly, we have created or adopted risk. If you created a risk or if you adopted the risk and you do nothing about it, you would be held liable. So if it is coming from something that you created a fire, you had a fire extinguisher, and what you didn't bother to what quench the fire with it, you will be held liable for what not quenching the fire, and that would be because you started the fire. So you should have done something to what put out the fire. Or if you adopt the risk, if you adopt a risk that you were not even that wasn't created by you, you'd be held liable for omissions. And then we have the second element of breach. The second element of breach. This is where you what we measure what you did or didn't do to a reasonable person. So we measure what you did or didn't do to a reasonable person. What a reasonable person would have done. In Latin, it is called clafan or omnibus. That's what a reasonable person would have done. Now, we measure what you did versus what a reasonable person would have done or wouldn't have done in the situation. If your actions or inaction falls short of what a reasonable person would have done, then we say you've breached the duty of care. So the real issue here is whether the person's actions of the defendant were sufficient to meet their duty. To determine this, the court has what? A standard of care that they use. So the standard of care is the standard of a reasonable person. So if what I did or didn't do, if it falls short of what a reasonable person would have done, then I am liable for breach of the duty of care. So first, we need to establish that I owe a duty of care, and then now they will measure my actions or inactions. A reasonable person in that circumstance, what would a reasonable person or what would a reasonable person do on another circumstance? When they take what I did versus what a reasonable person would have done, and they realize that my actions falls below what a reasonable person would have done, then we are saying that I am what? Liable for a breach. I have breached my duty of care. However, we have something known as professional negligence, where with professional negligence, it comes as a result of you hiring a professional to do some work for you. So if we have a professional negligence, yeah, we do not look at just what a reasonable person would have done. We look at what a professional in your field would have done. So a lawyer, a doctor, a teacher, anyone who's a professional, look at what the professional would have done. So with the normal test, we look at what a reasonable person would have done. But with a professional test, we look at what someone who's in the profession would have done. And then you compare it with what you did. You do an operation on someone, you leave some of the tools in the person. What would a reasonable person do in that circumstance? The reasonable person will take all the steps to make sure that there are no tools left in the person. So that is what measuring against a professional conduct. But when it comes to a normal negligence, you're looking at this from a view that is this what a reasonable person would have done? And if the reasonable person would have done that, then you are liable for the breach of what? The duty of care. Now we have something known as res ipsa liquiter. It's a Latin word which means the facts speak for themselves. The facts speak for themselves. Now, this is something that is kind of tricky when it comes to res ipsa liquiter. Now, we are saying that negligence is not actionable per se. You need to prove that the person owes you a duty. You need to prove that the person has breached the duty. And you need to also prove that what you suffered a damage. But sometimes you cannot prove that the person has breached the duty. Sometimes it becomes very complicated to prove that the person has breached the duty. Now, with res ipsa liquiter, we are looking at it from the perspective that if something bad happens, and that thing was as a result of or that thing was in control of the other person, that means that thing wouldn't have happened if the person has done everything right. But you just cannot prove that the person has breached it. You can still win in the negligence suit. So here, you proving the breach doesn't now fall on you. It falls on the defendant. It falls on the person that you are suing. Generally, when it comes to negligence, everything falls on the plaintiff to prove it. But when, with the exception of the res ipsa liquiter, we are saying that something bad happens. You cannot prove or you cannot have evidence that the person actually did something wrong. But the bad thing would have happened if the person has done everything right. That is what this means. So with breach, you have to prove that the person didn't do what someone in their field or what a reasonable person would have done. But with this fact speaks for themselves, we are saying that in these circumstances, something bad has happened. You cannot quite put your hand on what a person did wrong, but there's evidence that the person did something wrong, because if the person hadn't do something, or if the person didn't do something wrong, that bad thing wouldn't have happened. So with this one, the proof shifts from the plaintiff to the defendant, for the defendant to prove that he didn't do anything wrong. If the defendant is not able to prove that he didn't do anything wrong, then you'll be successful in a suit for negligence. So generally, like I've been saying, the plaintiff must prove that you did something wrong. However, when it comes to res ipsa liquiter, the burden of proof moves from the plaintiff and it goes to the defendant to rather prove that he didn't do anything wrong. So let's read. So this applies to circumstances where the cause of the injury was under the control of the defendant and that the incident would not have occurred if he had taken proper care. Now, in that case, the plaintiff would not be required to prove the basic elements of negligence. That means that the burden of proof rather shifts to the defendant. So it can be applied in medical cases. For example, Mahon versus Osborne, where a surgeon had to prove that he was not negligent to leave a swab in the patient. Now you've left a swab in the patient. The patient was under. The patient cannot actually prove that you didn't do everything right. But if you had done everything right, you need to have left something in the patient after the surgery. So I take it again. Here, you've left a swab in the patient. The patient cannot necessarily prove that you didn't do everything right. That means that the patient cannot prove that you breached it by not doing everything right. But the idea is that if you had also done everything right, you wouldn't have left the swab in the person. So here, the patient doesn't have to prove anything. You, the doctor, have to prove that you did everything right, but rather something happened and then you left the swab in the person. So if the doctor cannot prove, then the patient will now win. So here the burden of proof now moves from the patient and it goes to the doctor to prove that he didn't do anything wrong. Now, the maximum applies only where there's an accident that is unknown, or where the cause of the accident is unknown. So you cannot put your hand on the cause, but you know that definitely the defendant didn't do something right. So even though you cannot place your hand on the cause of the accident, you know that definitely the defendant didn't do something right. That is what it resulted in that accident. So with here, you can sue even without having to prove breach. So in Cloutier and another versus Nelson, and in Scott London, there was inference of negligence. There was inference of negligence. So we are saying that under res ipsa loquitur, you don't have to prove the wrongdoing, because without the wrongdoing, the accident wouldn't occur or the injury wouldn't occur. And now we have damage. Now, like I said, damage can will be split into two. One, did you suffer a damage? And then two, was the damage as a result of the breach? So with the damage, you're looking at two things. One, did you suffer a damage? And two, was the damage the result of the breach? So if you prove that yes, the person owes you a duty of care, you prove that yes, the person also breached the duty, so there was damage. However, if you cannot prove that the damage came as a result of the breach, you will not be successful. That's why I say with the damage, sometimes people split it into two, but it doesn't matter. All you need to know in your explanation is that when you're explaining damage and you want to combine it into one heading, you should know that one, the person suffered a damage or an injury, and then the injury was a direct, or the injury is directly can be directly inferred from the breach of contract. So let's say you were eating something that you bought. You're eating something that you bought, and then or you were drinking something, and then after drinking, I just said a sound, and then after drinking, you realize that I'm hearing a sound. I don't know. Okay, so it's something different. And then after drinking the item, you realize that there was a funny taste at the bottom, and then you open you cut it open and you realize that there was nuts in it, and then you are not a big fan of nuts. If you have a stomach upset, and then you go to the hospital, and the hospital tells you that even though you have a stomach upset, the stomach upset is not directly related to the drink that you took, you would not be successful in the suit. So here we are saying that there must be a damage, and the damage must be as a direct result of the breach. So, damage. The plaintiff must prove that he has suffered a damage or an injury, and the injury was as a direct consequence of the defendant's breach of duty of care. and the damage is also not too remote. So the plaintiff must establish causation. That is causation, meaning that what you did caused me my injury. If there's a break in that causation, the plaintiff will not be successful. So, thus, there must be a chain of causality from the defendant's actions to the claimant's loss or damage. What you did led directly to me getting a loss or me losing something. And as such, I can win a suit against you for negligence. So the court applies the but-for test in establishing causation. So if not you, or if not for your actions, the person would have suffered. So the but-for test is very important to prove whether there's causation or not. That means that when you take the person's actions from it, would you have suffered that loss? Someone was playing with fire in their house, they became negligent, and then your house got burnt down. With this example, you can see that if the person wasn't playing with fire, your house wouldn't have gotten burnt down. So there's a direct causation, or there's a direct causation from the fact that the person was playing with fire, and then your house getting burnt down. So here you can prove causation. If the person hasn't played with the fire, then your house wouldn't have gotten burnt down. So there's a direct causation from it. So we are saying that here, yes, there must be damage, but the damage must be as a direct consequence, or there must be a direct chain of causation from what the person did to your injury. If there is a break in it, then the person will not be held liable. If someone is cooking with gas, we'll be going to that example soon, or that one is also an exception. If someone is cooking with gas, and then there's a lightning, and then the lightning strikes the gas, it explodes, and then let's say 5 houses in the neighborhood gets burnt down. The person would not be held liable because the person cooking isn't a direct consequence of your house burning. People cook all the time. However, it was the lightning that struck that led to the burning of the 5 houses. So we are seeing that there must be a direct link from what the person did to actually your cause. And if the person hadn't done what the person was doing, would you have suffered? That is what we are looking for. So that is what the but-for test. If not for the person's actions or inactions, would you suffer the damage? So the but-for test implies that the plaintiff would not have suffered the damage but for the act of the defendant. Now, sometimes there could be one sometimes there could be more than one possibility for the damage. With this one, the defendant will only be liable if his actions was the most likely case. So sometimes there are multiple causation or there are multiple possible causations. But we'll just be looking at the fact that was the defendant's action prominent from all the possible actions. And if his action was a prominent one against all the actions, then he would be held liable. Now, what I mentioned, we have something called novus actus intervenience, which means that intervening unforeseeable events. Now, this occurs after a defendant's negligence act and operates to precipitate or worsen the plaintiff's loss. So here there's a break in the chain of causation and the defendant will not be held liable. Like the example that I gave, the defendant is doing something. However, if not for an unforeseen intervening act, the damage will not be caused. So if there's an unforeseen act and then it increases the likelihood or it makes the thing worse, then the defendant is not going to be held liable. Like I just said, you are cooking, you are doing something with fire in your house, and then there's a lightning strikes, it hits the fire, everything gets burnt down. Here, you would not be held liable. We are seeing that there's an intervening unforeseeable event that caused or that made the actions worse. So with the elements, we can group it into 3 sometimes can be broken down into four, like I said, depending on how you want to explain it. But just make sure that all the elements are in it. So one, when you go to court and you want to prove for negligence, the court is going to ask you, one, did the defendant owe a duty of care to the plaintiff? Two, did the defendant breach that duty? Three, did the plaintiff suffer a legally recognizable injury? The injury is the same as a damage. And then four, did the defendant's breach cause the plaintiff damage? So all of these four things, so the third and fourth points could be merged into one, depending on how you want to write it. But we are saying that with the third and fourth one, there should be an injury or a damage, and the damage should have a direct causation between what the defendant did and then what the loss that the damage that the plaintiff has suffered. So these are the elements that you need to prove in order to win a negligence suit. Now, here we have a minute aid to help you remember. We have A, B, C, D. A duty of care. B, we have the breach of duty of care. 3, we have causation. And then 4, we have damage. So this could help you remember the elements of negligence. A, B, C, and D. Now, we go to types of negligence. Types of negligence. Now, with types of negligence, we have ordinary negligence. Ordinary negligence. Now, this is where failure to exercise a reasonable care that a prudent person would have done under the circumstances. This is just what ordinary one. What you should have done or shouldn't have done, but you rather ended up doing what the opposite. And that's what an ordinary negligence. And then we have gross negligence. Gross negligence. This is where there's reckless disregard for the safety and the lives of others. There's reckless disregard. You just did anything recklessly without thinking about the safety of others. So this is a step ahead of ordinary negligence. Now, at first, in Wilson versus Brett, it was held that negligence is just ordinary negligence with vituperative epithet, described as angry or what. So it is just negligence described with angry or abusive language. And then they were saying that as for this one, it is just the same ordinary negligence that is just being described with angry language. And then they both they're saying that it didn't lead to anything different. However, when it comes to Arvis Adomako, they actually made sure that they differentiated gross from ordinary. And then sometimes if you don't take care and there's a gross negligence, it can even lead to criminal actions. It can lead to criminal actions. So with the ordinary one, you fail to exercise reasonable care in an ordinary course of activity. But with the gross one, we are saying here there is a reckless disregard for the person's safety. And if that happens and they are able to infer the gross negligence, sometimes it can even lead to criminal actions. If you don't take care, the person can take you up on criminal actions. So, for example, in Arvis Adomako, the anesthetist failed to notice the disconnect between the oxygen tube, leading to the death of the patient. So here, as someone who is an anesthetist, here you need to take very good care and make sure that you check everything. So if you end up not doing your job well and you end up not checking everything, that means that you did something recklessly that has led to someone's death. It is seen as a gross negligence, and it could lead to criminal actions. And then we have vicarious negligence. Now, with vicarious negligence, it is the negligence where an employer will be held liable for the employee's wrongdoing. An employer will be held liable for an employee's wrongdoing. Now, the general idea is that as an employer, you should make sure that everyone that you employ is competent enough to do the work. Everyone that you employ is competent to do the work. That is one. So you must make sure that you provide all safety equipment or all equipment that is needed to do the job. You must make sure that you provide all equipment that the person needs to do, that the person needs to do their job. So if the person was doing his job, that's something the employer can be sued. Even if the employer didn't do anything and the employee did it, if the employee does something, the employer can be sued. Just because the employer, it is your duty to make sure that you employ people who are capable of doing the work rightly. So with the vicarious, this is where what? So vicarious is where you are doing something through someone. So with this one, we are saying that you can sue the employer based on the wrongdoing of the employee. That's why people sue companies all the time for something that what an employee has done or an employee in the company has done to them. So this applies to when one party is held responsible for the negligence of another, often in the what employer-employee relationships. So if your employee is negligent, you the employer, you might be found wanting. And then lastly, we have professional negligence. Now with professional negligence, it is the failure to meet professional standard. This is where, as a doctor, you didn't do something right, as a lawyer, you didn't do something right, and it has led to your client suffering some damages. And based on that, they can sue you because of the professional relationship that they have with you. And then we go to defenses against negligence. When someone sues you for negligence, what can you do to defend yourself? When someone sues you for negligence, what can you do to defend yourself? One, we have contributory negligence. Now, if you contribute to your own losses, then we are saying that you would receive a reduced compensation. If what you did contributed to the loss that you suffered, they are going to deduct as far as money you can calculate what you did from what the person did, and then what you're going to get only a fraction of the compensation that you are entitled to. So, for example, in Kutia Wusu versus Kuka, there was a driver who was driving recklessly. However, the passenger had stuck his arm out of his vehicle. So the passenger had his arm out of the vehicle, and then there was an accident, and it led to amputation of that hand. Now the court said that even though the driver was driving recklessly, if the defendant hadn't stuck his arm out of the vehicle, probably he would have gotten hurt, but not hurt to the extent that his arm would have gotten amputated. So based on that, you would be compensated, but you wouldn't get the full compensation. So if you contributed to your loss, you wouldn't get your compensation, or you wouldn't get your full compensation. You would get some compensation, but you wouldn't get your full compensation. That is what contributory negligence means. So here you've contributed to the loss that you suffered, and based on that, there will be a reduced compensation given to you. And then next, we have voluntary non-fit injury, which means that voluntarily acceptance of risk. So if you voluntarily accept the risk, then the person will not be held liable. Now, this is not negligence, but I would like to use this example to clarify before I come back to negligence. So in a boxing match, when you agree to fight someone in a boxing match and the person beats you up, you cannot sue the person for battery. Because you voluntarily accepted to fight the person. And after you voluntarily accepted to fight the person, when you enter the ring, you know the person will there's a fight between the two of you. So if the person hits you as hard as he can, and then you get hit, you fall down and go into a coma, you cannot sue the person for battery. Because you knew the risk before you stepped into the ring. So if you agree voluntarily, not force, not through force of yours, but if you voluntarily accept that I am entering into this particular item or this particular event, and you get hurt, you cannot sue. When you sue, the person can say that you voluntarily accepted the risk of being hurt. So now that you are hurt, you cannot sue the person again. So that's a defense against negligence. Now let's come back to negligence. Now, you know that, so this simply means that you are voluntarily accepting the risk of being injured. Now, if the defendant can prove that the claimant accepted the risk of damage or loss, he will not be liable. So, for example, in Hall versus Brookland, spectators at a motor race voluntarily accepted the inherent risk of such an event. So, when you're in a racing and then you are still in front, in race cars, you know that definitely sometimes the cars can get derailed and sometimes even the tires pop out of the cars. because of the speed that they are going. So if you do that and you go to that event, you are what voluntarily accepting the risk of being injured in that event. However, in Smith versus Bakers and Sons, they made a distinction between actually knowing and then what actually accepting it. Where they said that mere knowledge of the risk is not enough, you must freely and voluntarily what consent to it. So just knowing that you could get hurt is not enough. You must say, okay, I am voluntarily what accepting the risk. And if you voluntarily accept the risk and you enter into these sporting events, and then let's say you get hit with a ball, for example, with football, the player plays a shot and then what it hits your face. What you're hitting a football match, knowing that you are in the stands which is in front of you, and you could get hurt. But we are saying that just knowing it isn't enough. You must what accept it voluntarily and then what freely accept that okay, you are going to get hurt, and then what you actually what assume that risk. And if you assume that risk and you get hit in the face with a ball, you cannot sue the football or you cannot sue the organizers of the football game. Now, next we have inevitable accidents. There are some accidents that you cannot prevent. There are some accidents that you cannot prevent. So even if it came as a result of someone, and then the person couldn't have prevented that accident, the person can use that as a defense for negligence. So in Stanley versus Powell, the defendant was not liable for injury caused by a ricocheted shot. So he was shooting at something, and then what the bullet ricocheted. When you say a ricochet, it means the bullet bounced off. So it bounced off the item, and then what it hit someone in the eye. When that happens, there is no negligence. Because the person couldn't have what prevented it. The person didn't do anything wrong. Even though you suffered a wrong, the person shot at something else, but the bullet just was ricocheted and what it hit you. So this is what an inevitable accident. The person couldn't have what done it. So here there's a harm occurring without negligence and couldn't have been prevented. So because of that, the person will not be held liable. And then we have something called act of God, where they call vis major. Now, this defense applies when there is a harm caused by natural forces so extraordinarily that no human could have foreseen it or care could not have prevented it. So it doesn't matter how careful you were, you couldn't have prevented it. So in Nichols versus Maitland, the defendant was not liable when extraordinary rainfall caused its ornamental lake to flood and damage a plaintiff's property. So someone had lakes, ornamental lakes on his property. Now, under normal circumstances, if his lake floods someone else's property, there would have been what? Negligence, because your lake, you should have taken good care of your lake and make sure that your lake is what well guarded, that it doesn't flood someone else's property and then what destroys the person's property. However, there was extraordinary rain. It rained very heavily. The lakes got full up, and then what? It washed, and then what? It destroyed someone's property. Now, here we are saying that if not for the heavy rains, the person cannot control the rains. So, if not for the heavy rains, the lake wouldn't have overflooded and what? It wouldn't have what? Destroyed the other person's property. So, based on that, the person can check it up to what? An act of God, something that he couldn't have controlled. And it doesn't matter, even if he had put proper things in place, and then when there were guards in place, he had raised the elevation, he had done everything. Even if he had done that, rains could have still broken into those things, and then would have still flooded the place. So based on that, we are saying that when someone sues you and it was something that was out of control, something that you couldn't have prevented, you can prove, and then you can hide behind, or you can use vis major as a defense for negligence. Something that ordinarily the person would have won against you for negligence. If you can prove that there was something else coming into it that you couldn't have controlled, then you can use that as a defense for negligence. And also we have necessity. Now, if the defendants, now this applies when the defendants acted to prevent a greater harm. So when you did something to prevent a greater harm, you will say that you did it out of necessity. And based on the necessity, you will not be held liable for negligence. So if you do something to prevent a greater harm, even if it caused damage to the plaintiff, you would not be held for negligence, or you will not be liable for negligence because you did it out of necessity. So, however, when you're doing this, you should be careful to make sure that you still take proper care, or what there's still a due care when you are doing it. Because in Rigby versus Chief Constable of Nottinghamshire, even in emergencies, public authorities must act with reasonable care, and failure can result in negligence. So here, I think it was a gun shop here. It was kind of a gun shop. So the thief was hiding in the gun shop. The accomplice was hiding in the gun shop, and then they threw explosives in the gun shop. Now, if you throw explosive in a gunshot, you know this kind of firepower meeting firepower, and then what, it destroyed someone's property. Now, even though they were acting in the public's good to make sure that they flash out a criminal, the court said that even if you are doing that, you must make sure that you do it with reasonable care. Because as a human being, you know that if you throw explosives into a place where there are more explosives, bad things could happen. So even though necessity can be a defense, we are saying that you must still act with reasonable care. Other than that, you cannot use necessity as a defense for negligence. Now, next we have illegality, S2P cosa. S2P cosa. Now, it comes from the legal maxim S2P cosa non-orienta actio, which means that no action can arise from a dishonorable cause, an illegal cause, and an immoral cause, a cause that is against public policy. Now, if an action arises from illegality, you remember the court is not going to enforce it. So if something is arising from a dishonorable cause, an illegal cause, the court is not going to help you get anything from that particular event. So with this, we have Ashton versus Tenor. Now with Ashton versus Tenor, the two people went to rob someone else. And then when they went to rob the person, there were two people, and then one person was driving the getaway car. Once he was driving, he was drunk. So they were going to steal something. The one who was going to drive the getaway car was drunk. They stole the item, and then what? They were running from the police. And because he was drunk, they got into an accident. And after they got into the accident, the other passenger, that's the other thief, got hurt. And the other thief wanted to sue the driver of the getaway car that his drunkenness caused him the harm. So he wants to sue the person in court. But the court said that just because the actions arise from the fact that they were driving away from a criminal act, the court is not going to enforce that particular damage. And in a normal circumstance, if someone is drunk driving and then you're a passenger and you get hurt, the court is going to help you recover some compensation of damages. However, because they were driving away from a criminal scene, the court is not going to help it. So the idea is that the court is not going to help you recover anything from a dishonorable cause. So if you do something that is illegal, something that is against public policy, and you want to recover from it, the court is not going to help you recover from that act. So in Ashton versus Tenor, a burglar a burglar got injured while escaping with his partner who was drunk driving, could not claim damages. As such, recognize the duty of care in such circumstances would undermine public policy. If we would enforce illegal actions by saying that even though it is illegal, the person got hurt, the person needs some compensation, that is not going to help the public. That would mean that the public could bring anything that is illegal to court, and the court is going to enforce it just because there was a wrongdoing or the person has hurt you. So here the court does this to make sure that if there's an illegal act or there's an act against public policy, you will not even bother to bring it to court because you know that the court is not going to uphold such particular transactions or such particular acts. Next, we have strict liability. You remember we've already discussed strict liability. When we're saying that here there's liability imposed for reason other than fault. It is not your fault, we understand. but you didn't do something right. That is why something bad has happened. So here there's what a strict liability. It's not your fault, but your product or what you are doing has caused harm. So based on that, the person can sue you based on strict liability. Now, strict liability for damage is approximately caused by abnormally dangerous or exceptional activities. Now this is where what they apply this doctrine. So abnormal or dangerous activities can be classified into three characteristics. One, we say the activity was involves potential harm or a serious nature to a person's property. Two, the activity requires high degree of risk that cannot be completely guarded against by exercise of reasonable care. And then three, the activity is not commonly performed in the community of our area. So if that happens, we are going to see that there's what a strict liability. You are dealing with what a highly dangerous item. Now, the highly dangerous item, if it hits someone, we are not going to say that you did everything right, so you can go scot free. You yourself, inherently, you know that what you are doing is what very harmful. And if you don't take all necessary steps, it can hurt someone. So if it goes out of control and it hurts someone, they can sue you based on strict liability. Now, it can also apply to harms caused by animals. Harms caused by animals. So if your animal destroys someone's item, it is not your fault, but your animal has destroyed someone's item. So the person can sue you based on strict liability. Now we have product liability. Now, product liability, the idea of product liability is where your product has caused someone harm. Now, if someone's product has caused you harm, you have various avenues that you can sue. So you've taken something and then what? Your stomach is upset. You've used something and the thing has affected you badly. You have these bases that you can see. We've already discussed some of them. So you can see based on negligence, you can see based on misrepresentation, and you can see based on what? Strict liability. So when someone's product causes you harm, you have an avenue to choose between these things and choose which one what perfectly suits what the product has done to you, and then you can sue them based on that. So this is the basis of the suit. When someone's product causes you harm, you must choose between these three. Now, we've already done negligence where we said that what there's a duty of care, and then the duty of care was breached and then there was damage. So if you feel like the one who produced the item didn't exercise enough due care, you can sue based on negligence. Now, if you also realize that the person misrepresented something and that is what has caused the injury, you can sue based on that. And also, if you cannot assign blame, but the product has caused you some harm, you can sue based on what? Strict product liability. So let's take them one by one. So if you want to sue based on negligence, you must make sure that the manufacturer has failed to exercise a due care to make the product safe. And any person who is injured from the product can sue for negligence. That is Donovan versus Stevenson. However, if the plaintiff fails to prove causation, the action will not be successful. Yeah, as I've already mentioned, it has all the elements of negligence. If you are not able to establish causation, that what they did caused you that harm, then there is not going to be what successful suit for negligence. So one basis is what? Product liability based on negligence. And then we can have product liability based on misrepresentation. Now, this is when a manufacturer or a seller misrepresent the quality, nature, or appropriate use of the product, and the user gets injured. They may sue for liability. So in Baxter versus Ford Motors, they established that manufacturers are liable for false misrepresentation made in advertisement when consumers rely on them. These people who sell drugs in cars, I'm not saying all of them are bad, but I'm saying that one drug can cure about 1,000 ailments. Now, if they tell you that something can do one thing, and then you go ahead and you take it, and then it doesn't cure it, or it didn't cause you more harm, you can sue them for negligence. So you can sue them for what? You can sue them for misrepresentation. Because the person has what lied to you, the person has misrepresented the fact that the item can do something, while the item cannot do that. So based on that, you can sue them for misrepresentation. And then lastly, we have strict liability. When a manufacturer has exercised a reasonable duty of care, but still the item injures someone, you can sue based on strict liability. So it because the product was what dangerous or was unsafe, you can sue the person for for strict product liability. So when a product injures you, when you eat something and injures you, use something and it injures you, you can choose the one that it fits properly. If you think that they didn't exercise reasonable care, they can sue based on negligence. If you think that it was because of a misrepresentation that they did on their product label, they tell you that when you eat this, you are not going to get a stomach upset. You eat it and your stomach is and you get stomach upset, then you can see them based on what misrepresentation. However, when the person has exercised due care on everything, but the product still causes you harm, you can sue them based on what strict product liability, just because the product was dangerous and unsafe. Even though they put everything in place, the product has still hurt you. You can sue them based on strict liability. Now we have types of defects. When it comes to products, we have types of defects. These are just defects. So defect that you can watch out for when you are looking at what products. The first one is the basis that you can sue. When a product injures you, the basis that you can sue. These are just what types of defects. Now, when we have manufacturing defects. Now, this is where a product departs from the intended design, even though all possible care was exercised in the preparation and marketing of the product. So here it's just a manufacturing defect if it is what deviated from the intended design. Now, liability is imposed regardless on whether the person was acted reasonably. So you intended to design a product in a particular way, but it ended up being what or coming out a different way, which hurts someone. The person can sue you based on this defect. And then two, we have design defects. Now, the design defects, we are saying that this is where if a foreseeable risk or harm is posed by a product, that could have been avoided by adopting a reasonably alternative design. So if you could have looked out for an alternative design but you didn't look for it, and then your design that you use hurt someone, they can sue you based on what? A design defect. And then we have a warning defect. A product may be deemed defective because there's inadequate instructions or warnings on a situation where a risk or harm that was foreseeable could have been prevented based on what? Proper warning. That is why you would see drugs and they have multiple warnings and a lot of warnings. You could buy headache drug, a drug that is meant to solve headache, and they will tell you that the side effect is migraine. Now, they conducted a study, and then even if there's a chance of someone getting a migraine, they have to put it on it to warn you that if you take it, it might cause these things. So if you do not warn them appropriately, that's why anytime that you buy a drug, there's this small paper inside, and they've written a lot of things on it, warning you on how to use it, when to use it, and if certain circumstances apply, do not use it when you are pregnant, do not use it when you are breastfeeding. They tell you all of these things. So this is what they're warning you. If they don't put these warnings on it and you get hurt, you can sue them. Now, when you pick this parazone that is parazone that is they will tell you that do not consume. Everybody knows that if you consume bleach, or a reasonable person would know that if you consume bleach, you would get what? Hurt. You might even die. But they still go ahead and put it on it that do not consume. And do not make sure it doesn't come into contact with your eye. They tell you all of these things to make sure that you are not able to see them for what? Warning defects. So even if a reasonable person wouldn't know it, they still warn you. They tell you that do not leave it within what? Some distance of what? Someone who's less than 5 years old or someone who's less than 3 years old. So they warn you based on all of these things. And even if you buy certain toys that are very small, they tell you that do not leave the toy with a kid while the kid is playing with it unsupervised, because the kid can swallow that toy. Also, if you buy certain liquids where the liquids are in big barrels, they tell you that do not leave that barrel with the kid, because the kid can fall into that liquid and the kid can suffocate. So they do all of these things to make sure that they are warning you. So they warn you to make sure that you do not get hurt. And if they warn you and you don't heed to the warning and you get hurt, you cannot sue them based on a warning defense. Now, next, we go to thought of defamation. Thought of defamation. Now, this is where someone says something that is untrue. Here, the key word is untrue. And in court, what is true and what is untrue is based on evidence. What is true and what is untrue is based on evidence. So even if someone is a thief and you go around telling people that he's a thief and you cannot prove that he's a thief, the person can sue you for defamation and the person is going to win. So here we are saying that the statement should be true for it not to be defamation. And for the statement to be true, you must have proof that the person is what? Doing whatever you are letting the person is doing. Now, if you are a thief and it is true that you are a thief, and I have evidence to prove that you are a thief, and I go around telling people that you are a thief, that is not defamation. That is not defamation. Defamation is where the statement is false, and I go around spreading it against you. So defamation was defined by Byron Pike in Patita versus Copeland as publication without justification or lawful excuse, calculated to injure the reputation of another or exposing the person to hatred, ridicule, or contempt. So when you publish false information to make sure that, one, the person's reputation is injured, or if you expose the person to hatred, to ridicule, or to contempt, we say that you've defamed the person. Now, defamation could either be spoken or written. When you write it, it is defamation. When you speak it out loud, it is what? Defamation. Now, they cause people to be shunned or to be avoided, or they expose them to hatred, contempt, or ridicule, or to disparage the person from his office, profession, calling, or trade. Now, words meant to damage a person's or a person in his profession or business can also be what? Defamatory. Now, however, in Bonsu versus Forsen, it was held that words that are spoken in confrontation cannot be defamatory because right-thinking members, that a reasonable person, is not going to take it seriously. So if you are arguing with somebody and the person has insulted you and you are feeling very hurt, in the heated argument, excuse me, say if you call the person a prostitute, so there's a back and forth, call the person a prostitute, you insult the person just because you want the person to get hurt and not because it is true. Generally, no defamation, because people who are seated there know that everything that you are saying to each other, you are just saying to each other to hurt the person, and it will not necessarily be true. So in a heated confrontation, between two people, words that are said, we say that a reasonable person is not going to take them seriously, and based on that, it cannot be defamatory. So we have elements of defamation. One, there must be publication by the defendant. We'll look at what constitutes publication. But publication essentially means that making the news known to another person. So if you make the news known to another person, then there is publication. Now, the publication concerned the plaintiff. I make a publication that is concerning you, and if it concerns you, you can sue me for defamation. Now, in Nisted versus London, if the publication concerns you, you can sue and you would win for defamation. However, you can only defame members in a group, but not the group or the class. So if I say something, I'm not offending everybody, but the individual who the thing is in relation to, that individual can sue me for defamation. Now, also, political parties, local authorities, or department or central government cannot sue for defamation, as it would unduly restrict freedom of speech and public criticisms of the government. That is in Dasha County Council versus what? The Times newspaper. So if I say something wrong about a political party, that is a political party in general, about the government in general, I cannot be sued for defamation. I'm not going to use a real political party, but if I tell you that, oh, as for this political party, they are all thieves, the political party itself cannot come and sue me for defamation. So the political party, that means that the whole political party, I don't want to use any political party, but the whole political party cannot come and sue me for defamation. So that's why people can just go around making statements. As for this political party, none of them have sense. As for this political party, they are all corrupt. As for this, that's why people can make all of these statements. So if the statement is in relation to a whole political party, a central government, or let's say a district government, we are saying that they in totality cannot sue you for the defamation. However, if you single a minister out and you call the minister corrupt, the minister can sue you for defamation. So let's be guided. The fact that we say that we cannot criticize when we criticize political parties, or we criticize the government, such as the central government, they are not going to sue for defamation. If you single a minister out, or you single a member of parliament out, or you single someone out of the government, and you call the person a thief, a corrupt person, the person can sue you for defamation. Let's get those things clear. Now, we are saying that one, there must be publication. Two, the publication must concern the plaintiff. And then three, the publication is capable of a defamatory meaning. That means that in the natural context, it is capable of being defamatory. It must be interpreted by the right-thinking members of society. That's a reasonable person. They must not be taken out of context. The full words must be used in the natural meaning to establish defamation. You cannot take certain things out and say that the person is defaming you. When we are talking about defamation, we must bring the context. We must take what the person said in totality, and then we would wait and see whether it is actually defamatory. In Ghana here, or even around the world, we like to make this argument. When someone says something, they like to cut it, and then they will just bring a portion of it that sounds bad. But if you go to court and want to prove defamation, the court is not going to do that. The court is going to bring the whole sentence and the whole context. Now, if you bring the whole sentence and the whole context, and it is still defamatory, that is where you will be successful in defamation. However, if they bring the whole context and it does not connote anything defamatory, you will not be successful in defamation. So we are saying that the words must be capable of defamation in its natural or an ordinary sense. That means that what the person said in the natural and ordinary sense must be capable of defamation. There's an exception to this. We'll be treating it later. So please take note that there's an exception to this. Now, alternatively, in addition to III, the third point above, the facts or the circumstance surrounding the publication, it was defamatory to him, the plaintiff. So the circumstances will also be taken into consideration. After we've taken the words, we also take the circumstances. Now, the fifth point is talking about the privileges that you can look for. Now, the privilege that you are going to look for, we'll also be looking at it as defenses for defamation. So I don't want to mention anything here that is going to confuse you, but all you need to know is that there are defenses. But if the defenses was made out of malice, you would not be successful to defend yourself. That is what the fifth point is saying. Now, you remember I told you that with the words taken out of context, we are saying that the word should be in context, in its natural and original form, to make sure that it is defamatory. However, we have something known as innuendo. With innuendo, we are saying that sometimes the words themselves are not defamatory. But when we take it, or what, we take it from another angle, the words can be defamatory. So with innuendo, the words itself are not defamatory. But we could imply that the person meant it to be what? Defamatory. So here we are saying that sometimes the words used by the defendant are not defamatory in their natural ordinary meaning. However, inferences can be drawn from the circumstances in which the statement was made, and then it would make it defamatory. I'm sorry, this is a tree thing I'm going to say. I don't know whether everyone understands PC, but like after I'm going to interpret it. Now, when I say that Akwawe and Sahara, so for example, we are discussing thieves, and we say that Akwawe don't with and Sahara. The transliteration is going to be, as for this guy, his hands were written. But I'm talking about what? Someone who has a restless hand. Now, Akwawe and Sahara, in this original sense, doesn't connote anything. But in the situation that we are talking about, if I am calling the person a thief, or acquired in his hand, we are there 2 hours. Now, I'm not calling the person a thief, but I'm just saying that what the person has a restless hand, acquired in Sahara. Now, you cannot go around saying this because people could hide behind innuendo. And when they hide behind innuendo, they can just say things that could defame people. So we are saying that sometimes, if words in the original sense are not defamatory in nature, but we can make inferences, and those inferences could be defamatory, then you can sue based on innuendo. They were say acquiring in Sahano, and you see me in court and I tell you that I didn't call you a thief. You could infer from the circumstances and say that I actually was calling you a thief, but I was just being clever about it. So here we are saying that even though the general rule is that the words must be capable of defamation in its original and natural sense, if someone uses innuendo to defame you, you can still sue the person for defamation, even if the person used innuendo. So a claim for innuendo can amount to defamation. So it could be an otherwise innocent publication, even if it is innocent. And then you can still infer from it that it is it has caused you a harm. You can still sue them for defamation. Now, in Cassidy versus Daily Mirror newspaper, now, Mr. and Mrs. Cassidy were married. They were married. And then there was a publication that suggested that they were just engaged. They were married. And then there was a publication that suggested that they were just engaged. Now, naturally, if you are married and then I make a mistake that you are engaged, there is no problem with it. Because it doesn't mean anything. But you have to understand the context where in which this happened. This happened in 1929. And where women were a little bit conservative. And even at that time, you can still see that. But the woman said that this one meant that she was living in an immoral relationship. So they were married. The newspaper claimed that they were not married, or the newspaper claimed that they were just engaged. Now, as such, the woman claimed that it meant that she was living with a man whilst the man hasn't actually married her. And based on that, that made her kind of a mistress. And that made her look like she was living in an immoral relationship. And based on that, she sued and she won. So here, the statement could be innocent. But if it still goes ahead to hurt someone, because if you are married and I make a mistake and I tell you whether you are engaged, in its natural meaning, it doesn't mean that I'm calling you an immoral person. But the person could deduce that, hey, my friends and family know that we are living together. They know that we are married. Why are you going around telling people that we are just engaged? If you do that, it kind of connotes that I am living with a person immorally. Like how in our local context, if someone is not married but the person is living with someone, we assume that the person is living in sin. So they are not married, but they are living together. Same way the woman took it, because she's married, she's with a man, but they are saying that she's just engaged, which connotes that she's living in an immoral relationship. So based on that, she was able to sue the newspaper, and then she was successful. Now, if you have time, you could also look at Anthony versus University of Cape Coast. Now, we say there must be publication. Now, what constitutes publication? Because if there's something false that I'm saying, and I'm saying it to you, the person that the thing concerns, this is not publication. I hear that something is missing and people are blaming you, and I come to you and I tell you that, hey, I heard that you were a thief. What's going on with that? That is not what publication. Even though the statement is false, even though it can injure your reputation, I didn't tell a third party. I am saying it to you. Now, if I'm saying it to you, it doesn't constitute publication. So a publication is where a third party hears it. Publication is where a third party hears it. So publication means a party other than the plaintiff must have heard the defamatory words. The defamatory words must be communicated to a party apart from the plaintiff for there to be a what? Publication. Now, authors, editors, printers, and publishers may be liable for what? Defamation. Now, that a statement is considered published when a third party sees it, reads it, or hears it. So, however, if a person is not expected to hear it, but the person hears it, that is not defamation, or that is not publication, and that cannot lead to defamation. For example, I hear that you are a thief. I am asking you about it, and then someone is just passing by, and the person eavesdrops, and the person hears it. You cannot sue me for defamation because there was no publication. I didn't publish it on purpose for the person to hear. I was discussing with you, and then the person was heard it what the person was eavesdropping. So here we are saying that generally, if I do not intend for someone to hear it and the person hears it, I am not liable for publication, and that means that you will not be successful in a suit for what? Defamation against me. So we go into the details as to where there will be what? Publication, and where there will be no publication. Now, in Puram versus Hell, a letter that was dictated to a typist who took short claim as what? Defamation. Now, even though the person is just a typist, the person can be considered as what? The person is a third party, and because the person is a third party, here the person can also go and spread it elsewhere. So, because even though the person is a typist, at first people went to other people for them to type things for them and print for them. So even though the person is just a typist, the medium for which you just want to type your item, the person is a natural human being. As such, if you narrate to the person types it, it can still constitute publication because the person is a third party. 2, if the defamation or a letter is sent and marked private, there will be no publication if a worker opens it. So I have marked it as private and confidential, and I send it to you. However, a worker of yours opens it. Here, I did not intend for the worker to open it. Here, I did not intend. I made sure that I marked it private and confidential so that your worker will come and give it to you. Your servant come and give it to you. So if your servant opens it, I did not intend for your servant to open it. So even if your servant who's a third party reads it, I will not be liable for defamation, for publication and defamation. However, if I should have foreseen that your servant would open it, I will be liable for publication and what? Defamation. So here, if I couldn't have foreseen, there will be no publication. But if I would have foreseen that, oh, your servant could open it and they could read it. So in Gomeres versus Davis, if you could have foreseen that someone can open it, even though it has been marked private and confidential, you can still go ahead and what? Or the person can go ahead and see for defamation because you know that definitely someone would have opened it. So here with the publication, we are looking at what? Intentional and what? Unintentional. Generally, if it is unintentional, it will not be held as publication because you didn't intend. But if it is intentional or you could have foreseen, then there will be publication. Now, lastly, communication of defamatory statements between couples does not constitute publication. So kind of the concern that married couples get. they're in their room, they go out, they come back, they tell them they tell their stories, and then what? There's some false information passed by their wife to the husband or the husband to the wife. Here we are saying that generally it does not constitute publication. So communication among spouses does not constitute publication. That was in Wenham versus what? Morgan. Now we have types of defamation. With the types, we have libel and slander. With the types, we have libel and slander. Libel is permanent, slander is what? Transient. That's what? Temporary. So let's go through them. Now we distinguish between them because what? It is very important. Because one is actionable per se and one is not actionable per se. We've already discussed what actionable per se is. So libel. Libel refers to what? A permanent publication, such as writings, signs, pictures, and other means that confer some kind of what? Permanence on the statement. So if a statement is made that is what? Permanent, it is written down in ink, it has been printed, it has been drawn, it can amount to libel as what? Defamation. Now, it could be in the form of a notice, a book, a newspaper, even drawing cartoons, a statue, a photograph, a film. They can all amount to what? Libel. But usually it is in the form of what? Writing. But apart from writing, it can take all of these forms. Now, in Yusufich versus MGN Pictures, there was a film, and then it constitutes something that was not that was false on people or on someone who was alive. Now, you remember sometimes movies can write, before you watch a movie, they can write that this movie is based on fictitious people. Any resemblance was what? Pure what? Coincidence. Now, even if you do that, there's a limitation to it. That means that even if you write those things, and then a person can infer that what you are doing is in direct relation to them, they can sue the movie, and then what? They can get damages. If the movie has what? Cause someone to what? Ridicule or what? Or cause someone to what? Shun them. So even if it is in the form of a movie, even a cartoon, you draw a caricature, and then you have an influential person drawn, and then what? And then the person dipping their hands in someone's pocket, the person can sue you. You have an influential person dipping their hand in someone's pocket. That's implying that the person is what? Robbing someone. Now, in Ghana here, we have what? Some people that even if you draw any form of caricature of them, we can infer that this is, for example, network interference. Please, you can hear me. Please give me a thumbs up. I'm getting a notice that my network is being interfered with. All right, thank you. So, for example, if let's say this is an example, not a defamatory example, but I'm just looking at giving can be said to what match with someone else. In Ghana here, you know that when you draw someone who is bald, someone with a round head, and then the person is wearing what round spectacles, the person has with a very round head. The idea or everything goes towards the former president, because you can see that people draw a lot of caricature based on that. So that is what I'm saying. If you draw a cartoon, that bears a stunning resemblance to someone, and then it implies that the person is doing something wrong. Here, the person can sue you for defamation. So it can be a notice, a book, a newspaper, a cartoon. Excuse me. It can be a notice, a book, a newspaper, a cartoon, even a statue, a photograph, or a film. In all of these instances, we can see that what if you are implying that the person is doing something bad, and the bad thing that the person is doing is a false statement, the person can sue you for libel. Now, libel is actionable per se. Now, we make the difference between because what libel is actionable per se, because it does not need to be proved for actual damage. Now, if you write something of permanence, I do not have to prove that my wife has left me. I do not have to prove that I don't have to prove that I've lost my job. I don't have to prove any damage. I don't have to prove any injury. The fact that you've written something of permanence of me, that is defamatory in nature, I can sue you for defamation. That is libel. With libel, if I do something, I write something that is permanent, that is untrue. I write something that is permanent, that is untrue. You do not need to prove that it has caused you any damage or injury. You can sue me and you would win for defamation. Now we have slander. Slander is transient. Transient means slander is what temporary in nature. Now, slander refers to transient publications such as spoken words and what utterances. Under common law, slander is not actionable per se. With slander, when I say something that is bad and then it is false against you, you must prove that what I said actually has caused you certain harm before you be successful in a suit for defamation. So that is why we split the difference between what slander and libel. Libel is actionable per se, slander is not actionable per se. However, even though slander is not actionable per se, there are certain instances that slander could be actionable per se. I take it again. Even though slander is not actionable per se, there are certain circumstances under which slander would be actionable per se. So, for example, if you allege a criminal offense punishable by imprisonment, if I go around telling people that you are an armed robber and you are not an armed robber, I'm just telling people. You don't need to prove that people have sound. You don't need to prove that you've lost your job. The fact that I'm just going around telling people that you are an armed robber or a thief, you can sue me for slander and you'll be successful. So if you allege that someone has a contagious or infectious or repulsive disease, for example, HIV, AIDS, COVID-19, tuberculosis, all of these contagious and infectious and repulsive disease, if I allege that, you can sue me for slander. 3, impugning unchastity or adultery on a woman. If I go around telling people that, oh, this woman, she just sleeps around, people just sleeps with her. She doesn't need to prove that her husband has left her. She doesn't need to prove that, for example, her family is not speaking to her. All she needs to do is that get a hold of me telling people that she's sleeping around, and then based on that, she can sue me. So this one affects both people who are married and unmarried. So if someone is unmarried and you claim that the person is being unchaste, the person can sue you. And if someone is married and you claim that the person is committing adultery willy-nilly, the person can also sue you without proof of any injury or damage. And then lastly, when a defendant alleges that a plaintiff is unfit, incompetent, or dishonest in his profession, trade, or business, I go around telling people that, oh, this tailor, when you give something to him for over a year, the tailor wouldn't be your attire wouldn't be ready. If I'm not able to prove that the statement that I'm saying is not false, the person can sue me for what? A slander. Even if the person has not lost any job, the person doesn't have to wait to lose jobs before the person will sue me. 2, I tell you that, oh, as for this tailor, when you send your things to him, you just what? Or cut the material anymore. He will just what? Spoil the dress. The dress that will come out of it is not going to be what? The dress that you intended for it to come out of. The person should not wait to suffer some damage or should not wait to suffer some job loss before they can sue me. They can sue me even though it is slander. Now we go to defenses against negligence. When someone sues you for negligence, how should you respond? 1, we have absolute privilege. There are certain people, there are certain instances that someone can enjoy certain privileges. Those people, when they say certain things in certain context, you cannot sue them for defamation. For example, executives. This privilege includes communication between high-ranking officers of state, such as ministers, ambassadors, high commissioners. So the executive branch enjoys privilege, and this privilege is under what? Absolute privilege. So absolute privilege, if they are having communication between them and there's anything that is false in it, you cannot sue them for defamation. Two, we have judicial precedents. Judicial precedents. Now, every statement that you make by a judge, a juror, a counsel, a solicitor, parties, or witnesses are absolutely privileged. You cannot sue for defamation. However, you have to have in mind that if you lie in court, it is perjury. If you lie in court, it is perjury. So even though they cannot sue you for defamation, you can be what? Held liable for perjury. So if you make a statement against someone who is untrue in court, the person cannot sue you for defamation. However, that doesn't what resolve you from or doesn't absolve you from what being sued for what perjury or being held liable for perjury. Lastly, we have legislative instruments. When members of parliament are arguing, if they make any false statement against you, you cannot sue them for defamation. So parliamentary work is such that it requires unrestricted freedom of speech. So anything said by an MP on the floor of parliament for the purpose of debating cannot be held or used against him. So when you read Article 115 of the 1992 Constitution, it lists out all the privileges that the MPs enjoy. And one of the privileges that the MPs enjoy include not being sued for defamation, even if the statement that they are saying is false. For the purpose of argument, if they make any of these statements, you cannot sue them for what? Defamation. However, we have other ways of dealing with them. If the statement is actually seen to be false, then a petition can be made to the speaker, and the speaker is going to get some committee to sit on it to decide whether the statement was false or not. And after that, the MP would be asked to what? Render an apology and what? Correct that circumstance. But you cannot actually sue the MP for defamation. You'll be given an avenue for the firm to what? Come out and what? Correct the statement that you made. That is why in parliament, members of parliament can what? Make statements. No matter how wild it is, they just make these statements because they are covered under this absolute privilege. Now, apart from these three arms of government and their institution where they can enjoy absolute privilege, we have other types of privileges. Or this privilege is known as what? Qualified privilege that is enjoyed by other common law members elsewhere. Now, this is what applicable to what other instances that are not part of these three arms of government. Now, statements made whether private or public that is meant for the common good of the maker or the receiver is classified under qualified privilege. So, too good versus what? Spiral. Now, you are going into business with someone. I heard that the person is what? Someone who can what? Scam you. Now, if I come to you and I tell you that, hey, this person, I have heard that he's a scammer. So be very careful when you are dealing with the person. Even if the statement comes out to be false, the person cannot sue me for defamation. Just because the statement that I've made was in the interest of the receiver. So here we are saying that for qualified privilege, if you make the statement for your own interest or the interest of the receiver, or even for the interest of the public, for public good, if the statement turns out to be false, the person cannot sue you for defamation. So that is qualified privilege. If you make it for the protection of the maker, the receiver, or the public at large, they cannot sue you, even if later the statement is false. However, the key word is that you must make it for the interest of the person, either the maker or the receiver. There's another downside to this qualified privilege, where sometimes you make a statement out of malice, out of jealousy, because you don't like the person. The qualified privilege will not cover you under that. Qualified privilege is where there is pure intentions of who you was looking out for the other person. So if there is pure intentions and the statement is false, you can hide under qualified privilege. However, qualified privilege doesn't shield you from just going around and making false statements because you don't like somebody. Now, next we have fair comments. Sometimes you make a comment or an opinion for the public interest based on something which is factual. So if your opinion is honest enough, it can be a defense. So here, for example, the statement is made on a fact, but your opinion that you made was wrong. Then you can what? Hide under what? Fair comment when someone sees you for defamation. But one thing is that the comment that you are making should be based on a truth or a fact. So if the comment that you are making is based on a fact and the fact is correct, however, the opinion or the comment that you made seem to be defamatory in nature, you can plead for what? Fair comment. And then next, we have justification. Now, justification is simple. If whatever I'm saying is true, I can just say it. You were a thief, I say you were a thief. You're a thief. I'm not defaming you. I'm not making the statement, even though the statement is making people shun you, it is damaging your reputation. If you were a thief and I tell people that you were a thief, you were a thief. So justification can be one thing against what? Defamation. And this is the best thing against defamation. If I know I'm telling the truth, I don't care. If you are an immoral woman, you are sleeping with people willy-nilly, and I go around telling people that you are an adulterous woman, you cannot sue me for defamation. However, as I've already mentioned, for there to be justification, you must prove in court that what you are saying is true. So sometimes, if you know something to be true, or you've heard something and you believe it's true and you cannot prove it, it can be very dangerous if you go around telling people. Even though what you are saying is true, if you cannot prove it, it may be very dangerous. So before you say something and you choose to rely on justification, make sure that you can prove it in court that what you said is true. If you are alleging adultery, and then, for example, you can gather people who have slept with the woman who were not the woman's husband. You can gather them around and what? Provide in court. And maybe there are certain evidences where there was a picture of the woman entering their rooms. There was picture of the woman kissing other people and other things. Here you can show what? Evidence. You can justify that whatever he said was what? True. But like I said, for you to rely on justification, just relying on mere words or just saying people should trust you is not enough. You must be able to prove it that what you said was actually true. And then next we have consent. Yeah, Bukari.
Okay, good morning, sir. Thank you for the opportunity. A certain question just came into my mind, and so assuming you are with your wife, and then 10 years later you have two child. One of them wasn't your child, and you find out that the child is not your child. So can you sue the woman for defamation of defaming you?
Okay, so that is paternity fraud. That is not defamation. Defamation is where I say something about you that is not true.
Yeah, but the woman said the child was yours. So later, I found out that the child is not mine, and the news just moved all over the area, including my business partner.
Okay, so that is easy. The example that you are giving, I don't know whether Anthony can hear me. I'm breaking up. I don't know whether it is from my side or
yeah.
So
It's my network.
all right. So I hope everyone can hear me. But what I'm saying is that with defamation, it's not me saying something to you. It's me saying something about you. That gives what? That renders your reputation to come down, or that causes people to ridicule you, or that causes people to what? Shun you. So saying something about you, not something to you. I'm not saying there's no redress. There is paternity fraud, but that doesn't fall under defamation.
Okay. Thank you.
Yeah, you're welcome. So we're discussing consent. Now, consent is where I give you permission to say certain things about me. If I give you permission, you ask for my permission, and then I say, oh, we can say it, and then go ahead and you say it, I cannot sue you for defamation because I gave you the permission to say it. And then lastly, we have remorse. Now, remorse is not a complete defense. Remorse is a partial defense. Now, with remorse, we are saying that here, if you show the court that you are sorry, the court can reduce the compensation that you have to pay. Even in crime, if you show remorse, if you plead guilty and you show remorse, there are certain reduced sentences that you can enjoy. So based on that, still when it comes to this defamation also, you could enjoy reduced compensation payments or reduced judgment when you show remorse. So when you show remorse, remorse is a limited defense. It's not the full defense, but it's a limited defense where if you show remorse, the court consider, oh, you are remorseful of what you did. So based on that, the punishment should be reduced. And then sometimes, as I've already mentioned, sometimes defenses can fail. Sometimes defenses can fail. So why defenses may fail? Now, sometimes fair comment and qualified privilege can be defeated by proof of malice. So strict on third page 318 provides that malice means either of the following. One, the defendant did not believe the truth of his statement or was recklessly made the statement, whether it was true or not. And then two, when a person has a wrong motive, that the person has ill will, personal spite, or abuse of privilege. Remember, we have what? Qualified privilege. Where I said that if you are making statements for the interest of the maker or the receiver, you are what? Covered under what? Qualified privilege. Now, if we find out that you made it out of malice, I don't like someone and I go around telling people that, oh, this guy is a scammer, you don't think he's going to scam you. And then when I'm sued, I try to hide under qualified privilege and say that I did it for the benefit of the other party. The court is not going to listen to my qualified privilege, my defense, just because I made it out of malice. So we are saying that under fair comment or under qualified privilege, if you make a statement out of malice, that defense is going to fail. If you make the statement out of malice, the defense is going to fail. So that brings us to the end of thoughts. So we thought we really did three main ones. We did negligence, we did strict liability, and then we said that product liability can fall under either negligence or it can fall under strict liability, or it can even fall on misrepresentation. As we've already done under contract, we understand the concept of misrepresentation. So it can also fall under misrepresentation. And then we can also have professional negligence, where we have a professional who hasn't done his job well and has caused certain harm. And then we do defamation. The statements that we make to other people, we must make sure that the statements are true, either that we can be sued for defamation. Yeah, Rita.
Oh, sir, please, my questions are two. The first one is, let's say you are a class teacher and the children went for break. So when they came out from a break, one of the child wasn't there, but you did not notice because of the class size. Then, unfortunately, you heard that one of your people has been knocked down by a car. That's the child who did not come out from break. And please, can their parents sue you for negligence? That's my first question.
Yes, please. Yes.
Oh, okay.
They can sue you for negligence.
Oh, okay. And
this one, it can even be under res ipsa liquide, where the facts speak for themselves. So here, even though they cannot prove that you didn't do your job well, they can say that if you had done your job well, the kid wouldn't have been knocked down by a vehicle. So they can sue you for negligence. Yes, please continue.
Sir, please, what about if the school is gated, but the child, him or herself, went out?
So is it here Rita didn't finish, but since it's a continuation of her question, I'll answer before Rita continues. Now, the child, a gated school. If you are talking about children, I want us to be very clear about the type of children that we are talking about. So if you say it's a gated school, then definitely a child who is 5 years may find it very difficult to scale the gate. So here we will be talking about children who may be in junior high school. So if a junior high school skips the gate, that means that with all efforts of the teacher, the child skips out, then we can have contributing negligence because the child himself was contributed. The teachers have been doing everything. They punish every child that scales a wall. They do everything. They've even gated the school. And then you go ahead and then you scale the wall. The teacher may either have a full defense of negligence, or may have a reduced defense for negligence. All right, so Rita, I can continue your second question.
Please, my second question is it's about the defense against the negligence. Let's say a lady is in abusive relationship, that the guy always beats her. She doesn't complain, and she still went ahead to marry this guy. So they are married, and the husband always beats her, and now she is fed up. So she sues the man for beating her always. And then the man also defend himself for voluntarily accepting abusive marriage?
No. You are voluntarily accepting the marriage. You're not voluntarily accepting abusive marriage. No. And this one even falls under battery. With battery, you are beating someone that you're not supposed to be beating someone. So with battery, no. That is under battery. Battery, if you beat someone else, the person can sue you in court. That's the idea of battery. I thought you even come to say that the woman struck back and the man fell down. Can the woman go in for self-defense? I thought that was what the question was going.
No.
But with your question, the answer is that no, the man cannot assume that defense.
Okay,
is it voluntarily accepting the risk? It's like, let me break your question down into two. Voluntarily accepting the risk is like the man beats you, but definitely the man would apologize, the man will try to stop, and then maybe you enter into the marriage and the man still beats you. Now, voluntary acceptance of risk is where, even this one, I'm not sure it is going to be a defense, but for the sake of this example, this is where the man will tell you that, if you marry me and you do something wrong, I am going to beat you. And the man is like, okay. And I doubt any woman in their right sense is going to say, okay. So the presumption is, you remember when we say the voluntary acceptance of risk, we say knowledge is not enough. We need you to what? Actually consent to it. So just knowing that something can cause you harm is not accepting the risk. You need to consent to what? Accepting the risk. So consent what? So here, if the man tells you that, hey, I beat my woman, so if we marry and you do something wrong, I am going to beat you. If you say yes, then that, even with that one, I'm very skeptical. But even with, so that one, the man can go ahead and say that, hey, he told you and he said yes. But even with that example, I find a lot of things wrong with it, because as a woman, why would you accept the fact that a man will tell you that, hey, as for me, I beat my women if they do something wrong, and they say yes, the woman should just beat you? I really doubt that you would accept that risk. So with the voluntary acceptance of risk, if the man,
Doc, please, the example that you just gave, there was a clause of conditional that if you do this, so assuming I said, if I find out that you steal from me, I'll beat you. The man didn't say, I'll beat you. He said, if I find out that you are cheating on me, I'll beat you. So there was a clause. So the man is having a case.
See,
that if I find out that
Listen,
Mhm.
listen. An action will not be upheld by the court. You remember, if it is illegal or it is immoral or it's against public policy, you remember that. So I cannot threaten you or I cannot make you sign an agreement where I will do illegal things to you if you breach a contract. So, is it a lot of things are wrong with this agreement that I doubt the court is going to uphold it as a defense. First of
Okay.
all, a woman in their right senses should not agree to that, should not expressly agree to that. That is my first point. A woman in their right senses should not expressly agree to that. And even if the woman does, I doubt the court is going to accept that as a defense because the court is not going to uphold anything that has illegality or something against public policy as.
Okay.
So my answer is still no. No, the court is not going to hold that as a defense. No. You
Despite
batter
all that
someone.
clause.
No, I cannot tell you that I'm going to kill you if you step on my leg. And I kill you, your family members sue me, and then I tell them that it was in the contract that I can kill you. No, I don't have the right to your life. So if there is an illegal item as part of the negotiation, or there's an item against public policy as part of the negotiation, the court is not going to enforce it, and the court is not going to hear that. You remember when
Okay.
someone was getting away from a robbery, and then someone was drunk driving, his partner was drunk driving. He tried to see the partner, but the court wouldn't hear it. And another circumstance, when you drunk drive and injure someone, you'll be held liable. But because of the
Okay.
circumstance, the court doesn't want to tolerate anything that is tainted with illegality or anything against public policy. So based on that, I doubt the defense is going to hold.
Okay.
I intentionally used the killing as an extreme measure so that you would see that the court is actually not going to the court actually not going to what uphold the fact that I should get a right to kill you just because you stepped on my leg, just because we agree to the fact that if you step on my leg, I'm going to kill you.
Okay. Thank you.
Yeah. So yes. So no, that is not a defense. The defense for voluntarily acceptance of me beating you just because you've cheated or you did something wrong, even if it is expressed, the court is not going to enforce that particular behavior. Please, any other questions? All right. So if there are no questions, we will take our 10 minutes break by 9:26. As I've already been saying, let's not log out. This is just a 10 minutes break. Just stretch a little bit. If you want to take water, you can go and take water. At 10:26, we'll come back and then we'll continue with sale of goods. Continue with sale of goods. All right. So we'll break here and then we'll come back at 9:26. Yeah, hello.
Hi.
All right, so let's continue. We are going to do sale of goods. Now, sale of goods, but this is a contract that involves the sale, the selling and buying of goods. We have other forms of contracts. Anytime that you have an agreement with someone that is legally enforceable, you have a contract. However, we group them based on certain features. And based on the features, we have other laws that govern them. So, for example, if you have a hire purchase agreement, it's quite different from if you have a sale agreement. If you have a contract for service, employment contracts is different. So we have different types of contracts, and these different types of contracts are governed by other principles, even though they all have the umbrella of contracts. But because of the specifics in them, we try to what differentiate one from the other because we may have different parties who may have to perform different things. So based on that, we separate them and then they are governed by specified principles. So we are going to pick one of the contracts, narrow down to what sale of goods. Now, the sale of goods, a contract of sale of goods is regulated by Act 137 of 1962. That is the Sale of Goods Act. However, Section 80 recognizes that we also borrow from the common law. So we could apply the common law and customary law. You know that buying and selling started not today. So we have some customary laws that surround buying and selling of certain products. So it applies to the common law and customary law to the extent that is not consistent with the act. So if there is a provision in the common law or the customary law that is not consistent with the act, we still go by it. Now, with sale of goods, we are saying that the consideration must be partially or wholly money. For something to be considered a sale, there must be an element of money. For something to be sale, there must be an element of money. If there's no element of money, you have something else other than the sale. If there's no element of money, you have something else other than sale. So you say that that's a barter transaction, it cannot be called a sale of goods. So if you exchange a good for a good, it is not a sale. It is what? A barter transaction, not a sale. Here, there's no buyer, there's no seller. It is just what one person exchanging one item for the other. However, with a sale, those people who do this iPhone swapping, if I add money to my iPhone 11 and I get 12, that's a sale. The fact that I am adding money to my iPhone 11 to get 12, that makes it a sale. So we are saying that for there to be a sale, then I must either exchange money for the phone or I must add money to my phone and exchange it for your phone. So it must consist of wholly or what? Partially money. But the fact that there is money involved in the exchange, then we have a sale. We have other elements and then we'll be distinguishing them soon. But at this point, you should know that the price or the consideration in the sale should be partially or should be wholly money. So we have the parties, we have the buyer, and then we have the seller. Obviously, some of these things I'm going to discuss with you, you already know because up to this point in our lives, we've done a lot of buying and we've done a lot of selling. Certain things that we've been doing, we didn't know that there were laws that governed it. So here you are just looking at the legal principles. So there were things that you were doing out of the blue, but they are being governed by laws and they are being codified in our laws. For example, I'm not sure it is today that you heard that the parties in a sale, in a sale of goods agreement are buyers and sellers. We know that if I'm buying something and you're selling it to me, I am the buyer, you are the seller. This is not something that is foreign to us. Yes, there are certain principles may be complicated, and that is why we need the law. But most of the things that we are coming to discuss, most of the times we've heard it before, or even we've been practicing it, but we are yet to realize that it is codified in our laws. So now, we have key principles that we must look out for when we are going to sale of goods. Now, we are seeing that the seller must either have full title or the right to sell. Before I can sell something to you, I must either have full title of the item or I must have the right to sell. Now, having full title kind of implies I can sell it. Now, so I must either have full title. If something doesn't belong to me, I cannot give it to you. I cannot sell it to you. If I sell something that doesn't belong to me, you do not have ownership of the item. So that's the general rule. We'll be looking at this rule in details later. But here, I want you to understand that if I don't have full title, I cannot sell. Or sometimes, you remember agency. Sometimes I may not have full title, but I may have the right to sell. So even if I don't have full title and I have the right to sell, if someone gives me an item to sell on his behalf, I have the right to sell. So if I have the right to sell, then I can sell. So you are saying that the seller selling it should either be the owner of it or at least have the right to sell the item. Now, mere possession does not confer ownership. I could have something that doesn't belong to me. The fact that the thing is with me doesn't mean I can sell the item to you. Mere possession of the item does not confer ownership. 3, the seller must agree to transfer the property in the item. In contract, in sale of goods, you see property a lot. Even though property can mean two things, anytime that you see property, we mean the ownership of the item. So when you are selling an item, if you are just giving possession to the person, that is not the same as ownership. If you are selling an item, you must give the ownership also to the person. That means that the property is passing, or the ownership is passing from you to the person. And then also, it is not necessarily that the property should be transferred at the time of the contract. So if I buy an item for you, it is not compulsory that we should have the item delivered to me on that day. That is why we have executory consideration. You can promise to give the thing to me at a later date. That doesn't mean the property has not transferred to me. The property has transferred to me. However, the possession should not be transferred to me at that particular time. And also, we have other types of contract that we can have a contract where the actual property in the item would not also transfer to me until a later date. So we'll be looking at all of these types of goods and then how we treat all of these things later. But this is just something that we should note before we move on. Now, we say the contract is for a contract for sale of goods. Because we are coming to do sale of goods, we should know what is a good. What can be classified as a good? If anything cannot be classified as a good, then we are not going to treat it as a sale of goods. Then we would have different principles in different acts to take care of them. We have different principles in different acts to take care of them. So for an item to be treated under the Sale of Goods Act, it must be that we are trading in a good. And before we know that we're trading in a good, we should know what qualifies as a good. So we'll be looking at that soon, and then we'll be differentiating what is a good from what is not a good. But first of all, let's define what a sale of good is. So sale of good is a contract when one party, who is the seller, agrees to transfer property in goods to another person who is known as the buyer, and the transfer is supported by a consideration or a price. Remember, this is the same as what? A contract. But here we are specifying what? The parties in the contract, because it's what? A specified contract of what? Sale of goods. So here we're saying that there's one party who is the seller who agrees to transfer a property to the other party, which is a buyer, and it's supported by a consideration or the price. Now, according to section 81, goods are movable property of any description. That is the first thing that you should know about goods. Goods are movable. And it includes growing crops or plants or anything attached or forming part of a land, which has been agreed to be severed before sale by or under the contract of sale. Now, even though we are saying it could also include growing crops. That is what? Attached or forms part of a land. That is why a fruit can be a good. So even though the fruit is on a tree which is attached to a land, if it is being severed for the general reason that it will be classified under the sale of goods or for the purpose of being classified as a good, then it's a good. So here we have two things. One, we have what? Any movable property of any description. That is one. And then two, we have what? Growing crops or plants or anything attached or forming part of the land that can be severed Seven is that can be separated from the land. So this is the general definition of goods that is given to us by the Sale of Goods Act. Now you've heard property. Now, anytime you hear property being described in the sale of goods, it means a general property and not a special property. Now, general property means full title or ownership, and then special property can be what? Possessory only. Now, even though we can have two types of property, you have general property and special property. Anytime that you see property in a sale of good, we are referring to a general property. So that's what I want to prompt you. Anytime that you see that we are transferring property, we are transferring the general property, which has the full title of what? Ownership. So the sale of goods has made it clear that even though property can mean two things, anytime that you see property in the Sale of Goods Act, we are talking about general property. That is why the definition we have what? The seller agrees to transfer property. So the seller agrees to transfer full ownership. So if you are selling something, you are what? Agree to transfer full ownership to the other party for the what? For the price. So anytime you see property, have it in mind that we are talking about general property. That is the full ownership of the item. Now, let's look at what can be a good and what cannot be a good. But before that, let's look at it from the perspective where we have two types of properties. We can have real property and we can have property personal. Now, a real property refers to a land and everything permanently attached to the land. Examples include freehold estate and what? Buildings. So real properties are properties that are what? Permanent, that is attached to the land. So it is a land or anything permanent that is attached to the land. And then we have personal property. Now, personal property can be the same as what? A chattel. So when we say types of property, we can have what? We can have a real property and then we can have what? A personal property. But usually a personal property is known as what? A chattel. Now, a chattel is a legal term for what? Personal property. And what? Property, but less than freehold. Freehold is where the item belongs to you. So sometimes you can have interest in the land, but the land doesn't belong to you. For example, a rent. It can be classified as what? Chattel property. So it is what? A chattel real. So a chattel real is an interest in the land. So here it is not the land itself, but you have what? An interest in it. And the interest is not a freehold. It's a lease, it's a rent. Just that you have what? A leasehold in it, what? In the land. So I said with the chattel personal, we have two types. You have chattel with a personal property that is also known as a chattel. We have chattel personal and chattel real. Now with chattel personal, we have two types of chattel personal. We have a thing in action or a thing in possession. A thing in action or a thing in possession. Now, a thing in action is something that is capable of being possessed or moved around. For example, furniture, clothing, vehicle, money. They are all what? A thing in possession, something we can possess. And then we have a thing in action or chooses in action, where it is an intangible and it cannot be possessed. For example, debt, shares, patents, copyrights, partnership in a what? Partners in partners interest in partnership shares. So in a partnership, all of these things are not what? Things that you can possess. So it is a thing in action. All of these things are things that you cannot possess. So based on these whole classifications, where we have real and then personal property, and personal property being split into chattel personal and chattel real, and chattel personal being split into a thing in possession and a thing in action, we can derive that a good is a chattel personal other than things in action and money. So when you look at chattel personal, we can see that it has a thing in action and a thing in possession. So we are saying that a good is an item that is what a chattel personnel. It falls under a chattel personnel. However, it does not include things in action. That means that debt, shares, partnership, interest, all of those things are not goods. And also, money is not a good. We'll look at the complications of money later. But here, have the idea that generally, money is not a good. Generally, money is not a good. So we can split it into this, and then based on the split, we can know what to deduce from it and say that okay, so based on everything that we are saying, goods include all chattel personnel. However, it does not include a thing in action, and also it does not include money. Now, based on this, there's a diagram here just to illustrate, what's a good. So we have the real and then personal, which is chattel. Chattel being split into what? Chattel real and what? Chattel personal. And then we have chattel personal being tangible and intangible. That is a thing of possession and a thing in action. And then tangible can be furniture, vehicle, jewelry, livestock. And then intangible is what? Debt, shares, intellectual property. And then based on that, you can have what? A good. Now, a good is anything that is what? Tangible and movable, but it is not what? It doesn't include what? Money and what? Things in action. Now, moving on to the definition, when we say things are of the soil, what do we mean? Now, because product of the soil must always be sold with a view of the ultimate severance, under a contract of sale, it appears to now be what? Always a good. So because we assume that most of the time, when we plant items, we are going to sever the item and then what? Sell, or we're going to sever the item as a good. So now we view it as what? Goods. But it's not every time that it can be viewed as a good. But this is just what an implication that when I plant plantain and the plantain, fruits or the plantain is matured, I would have to what? Sever the plantain from the plantain tree. So based on that, when I sever it and I take it to the market, the plantain is now what? A good. So now people even by implication say that, okay, so the plantain on the plantain tree is a good, but we have to make sure that after either the idea is that to be severed, or it has been severed before it will be known as what? A good. Now, it is also very necessary to split the difference between things that are products of the soil or things attached or forming part of the land and the actual land itself. There's a difference between things that are attached to the soil and things that are interest in the land itself. So generally, things that are product of the land, things are product of the land until they are severed and then they are treated as goods. So things that can be severed, at the point that they are being severed, they can be classified as goods. And then the land itself, which is the interest in the land, that is the real property leasehold, those things are not, because those things are permanently attached to the land. So to be severed means that the good is capable of being separated from the land. So if the good is being capable of being severed from the land, or the item is being capable of being severed from the land, then we are saying it's a good. I remember I was watching something yesterday. Someone was explaining how unreal superhero movies are, where if sometimes there's an earthquake, the superhero can just move the building, carry the building to a different place. And the person was arguing that the building is a structure on the land. If you try to just move the building, it is on the foundation. So the building will not survive it being moved from the land. So you see, the building cannot be said to be a land because it cannot be severed. It's not capable of being separated from the land. The building itself, because the building has what? Foundations. Generally, buildings have foundations. So sometimes you see movies that sometimes there's an earthquake, you see that a superhero just separate the building from the land. But with actual science, you see that the buildings are being rooted into what? Foundations. That if they try to what? Scoop the building from the land, it might what? Collapse the whole building because the building is on the foundation. So that idea, we are saying that to be severed means that it is capable of being separated from the land. So if it is capable of being separated from the land and it is severed, then it is now a good. If it's not capable of being severed, it is not a good. So that's the idea that you can have when it comes to what product of the land and product that's what actually the land itself. Now, we go to details as to what is a good and what can be treated as under what sale of goods. Now, in Halabi versus Urelu, it was very, very important to distinguish this. Now, the person was selling the whole business. The person was selling the whole business. Now, if you're selling the whole business, you are selling the goods that you have, plus your goodwill, and also plus your, your freehold property or your leasehold property. Usually, when people are selling their business, that's what they are doing. Now, if you remember, I don't know where you are in accounting, but if you remember accounting, especially the accountants here, you would realize that businesses have goodwill. I don't know whether maybe you've done that or you'll be doing that next year, or you've already done that in the previous studies. Yes. Now, the management students, I don't know whether that is also part of the curriculum. I'm a little bit accounting biased, so forgive me. Now, if you have a business, you will realize that anytime that someone is selling the business, the person sells it higher than what the price of the things in the business. So if the person sells it higher, it means that there's a goodwill that the person is adding to it to sell. That's because the person has been there for a very long time. So because of that, if you are starting a business from the scratch, and if you decide to buy the business from the person, it will be easier to continue the business if you are buying it from the person than to start from the scratch. So because of where the person has built the business up to, the person has now gotten some goodwill that the person is also. So goodwill is what's intangible. You remember we did what? Things in action. So we are saying that if you are selling a business, the business could be separated into what the goods and the non-good part. So even though it is a sale, the whole transaction cannot be classified under what sale of goods, just because the business has a lot of items, and the items some are not classified as what goods. And also this one also separated the difference between a hire purchase agreement and a conditional sale. So there's a difference between hire purchase agreement and a credit sale. Now, with a credit sale, the property passes at the time of the contract. However, the payment is made at a later date or is made in installments. So if I'm selling my phone to you and I pass the ownership of the phone to you, and then you have to pay me in installments, we have a credit sale. The ownership has what passed to you. You are now paying me back on a later date. But with the hire purchase, the ownership does not pass until there is what a final payment. So if I make the final payment, that is where the ownership passes. So even though they may look similar, there's a difference between a credit sale, which is actually a sale, and then a hire purchase. So anytime that you are entering into this kind of agreement, dot the I's and make sure that you are asking whether the ownership has passed to you at that time, and whether the ownership will pass to you at the end when you make your final payment, because they are both handled differently. We have the Hire Purchase Act and then we have the Sale of Goods Act, and they are both handled differently. They may have some similarities, but they are both handled differently. We have certain rights of the hirer, certain rights of the purchaser. All of those things are there, distinguished from what the buyer and the seller. Hire purchase is also a different part of business law, but we are not treating it now. So what I'm saying is that here, when we are selling something, you must make sure that if the thing is something that is encompassing a good and something that's not a good, if you take the item as a whole, we cannot treat the entire item under what sale of goods, because it contains both what goods and things that are not goods. And then let's go to money. Now, generally, money is not a good. Generally, money is not a good. That means that when it is being when it is a currency, it is not a good. However, we have people who collect coins and people who collect money. So some people collect money as what a collectible, you know, some people have just for a collection's sake. Now, to that person, if that person is using it for a business, then that becomes a good. So in Morse versus Hancock, if the person is collecting it as a curiosity or as a collectible, then it can be transferred as a good. So sometimes you will see that some people will say that, okay, so because the old currency had certain elements that could serve certain purposes. 2000 cedis, that is 2000 Ghana old currency, which is what? I think which is just 20 pesos. They are willing to give you 100 cedis for what? The 2000 cedis note. The 2000 cedis note. That is the old currency note. So at that time, it can be a good. But money used as a currency is not a good. But if the money is what someone is collecting it out of curiosity, or someone is just collecting as a collectible, and a person can later sell it, that can be classified as what? A good. So that's the difference. The general rule is that money is not a good, but under certain exceptions, money can be a good. Now we have auction sale. We've done auctioneers, so these are what? So auction sales is what? A sale of goods, a sale of goods. But this is where the sale is being made at an auction. So Section 4 recalls the common law that governs the sale of goods. Now, a person who bids is the offeror before they realize what said that the person who bids is the offeror, and the bid may be accepted or rejected. Until the hammer falls down, the auctioneer, or when the auctioneer announces that the completion in any customary manner. Some people use hammer, some people just say accepted, but the conventional way is the hammer. Some people may have other ways of what completing the transaction. So when you bid, the auctioneer can either accept or what reject it. Now, a bid may be withdrawn before hammer falls down. And if you bid, you can withdraw it before the hammer falls down. You can same as the offer. You can what revoke your offer before acceptance, unless the auction is without reserve price, where the seller is what. So if the auction is without reserve price, the seller may also withdraw the goods. I'm not willing to sell anymore. However, if the auction is announced without a reserve price, the seller is bound to sell to the highest bidder when the auctioneer even the auctioneer refuses the bid. So here we are saying that if there is no reserve price, then it means that automatically you presume that the highest bidder should win. So if there's a highest bidder, it doesn't matter whether the hammer is down or not, the good goes to the highest bidder. Now we have sale of goods and other transactions. Now we differentiate between sale of goods and other transactions. So one, we have a sale and a gift. What's the difference between a sale and a gift? Now, a sale involves consideration, whilst a gift does not involve consideration. A sale involves consideration, whilst a gift does not involve consideration. A sale, I give you a good, you give me money. With a gift, I give you a good, you give me nothing in return. So with the lack of consideration, it differentiates a sale from a gift. And then we go to a sale and barter. Barter is what? Good for good. While a sale must what? Have an element of what? Money in it, whether it is wholly money or partly money. So the difference between a sale and a barter is that with barter, there is no money involved, but with a sale, there is either what? Partial money or what? Wholly money. Now, a sale and a bailment. Generally, with bailment, I give an item to you for you to use it to do whatever it would do, and then I would come back for my goods again. So generally, I don't pass property to you. Now, sometimes a bailment agreement could result in a sale. It could. But we are saying that generally, sometimes I come and keep my goods with you, and then at a later date, I'll come for it. That is what the distinction, between what sale and the good. Therefore, that it can become doesn't mean it's the same thing. A sale, I am passing property to you, I'm not going to come back for it again. With a bailment, I give an item to you, I would come back for my item at a later date. And then we have a sale and a hire purchase. Now with a sale, we are saying that ownership passes, or with the hire purchase, ownership passes when the final installment is made. But with a sale, there is what? Full what? Or there is what? Instant passing of what? The ownership. Even if the payment to be made later, that would be what? A credit sale. That would be a credit sale. Now, a sale of goods could be made in oral or writing. It could be made partly in oral, partly writing. It could be implied from the conduct of the parties. All of these are being gotten from the general contract rules. Now, the price, we've already discussed the price. We are saying that the price should be what? Either wholly money or partly money. Now, when setting the price could be fixed by the parties themselves. The price could be fixed by the parties, or it could be fixed by cost of dealing. I bring you a box of tomatoes. The tomato is the box is 500 cedis. So anytime that I deliver the box, I need not tell you the price. I know that you will give me 500 cedis. So sometimes the parties will explicitly set the price. Sometimes the price has already been set, and the fact that you bring me tomatoes means I'm going to pay you the price because it has already been set by our cost of dealing. However, sometimes the parties may agree that a third party should actually set the price. Now, this is common when we are doing valuations. For example, even if you are selling your business, there can be business valuation by external parties to determine the price that you should sell your business. So it is possible for you to allow a third party to value it and then come up with an independent valuation. So Section 7 takes care of that. And here we are saying that when it's agreed that a third party should value their goods, and for any reason the third party fails and cannot, the contract is terminated. Because the third party cannot evaluate it. So the contract is terminated. However, if it is the fault of the other party, so if it's the fault of one party, then it's liable for damages, or we can say that he's liable to pay a reasonable price for the item. Now, consume the goods, making evaluation impossible. He was held to be liable. Now, here we are saying that generally, if anything happens, the contract is terminated. But if anything happens because of the fault of a party, then the party will now be held liable. So, Section 2, subsection 1 also talks about capacity. Now, it provides that the capacity to buy is regulated by the general contract laws. Remember, contracts, the general rules that apply in a contract also apply under sale of goods, because sale of goods is also a contract. Now, anyone who under the general contract law is capable of entering into a contract may enter into a contract of sale of goods. Infants, persons of unsound mind, drunkards, I've made a mistake. It's not supposed to be drunk. It's supposed to be drunk. People who are drunk are restricted to some extent from entering into a contract. Now, when necessaries are supplied to a person under agreement, because it lacks which is voidable, it shall be bound to pay a reasonable price for it. So remember, children who are a contract of necessities and all of those things, they are all part of contract, and they all apply when it comes to capacity under contract of sale of goods. Now, terms under a contract. Now, with the terms, we have is it in a contract of sale of goods? In a general contract, we have conditions and warranties. However, when it comes to a contract of sale of goods, we have a fundamental obligation, conditions, and then warranties. Now, a fundamental obligation is something that the Sale of Goods Act has made very clear that if you breach it, it's a serious part of the contract. So here it has been implied in it. The parties can have their own conditions and warranties in addition to other conditions and warranties in the Sale of Goods Act. But there's a fundamental obligation that no matter what, you are binded by that fundamental obligation. And that is what has been given by the Sale of Goods Act. So generally, when you breach a fundamental obligation, it leads to rescission and damages. When you breach a condition, it leads to rescission and damages. If it's something that there's an argument that some conditions under sale of goods could be a minor condition. So based on that, minor conditions could lead to warrant damages only. But some people argue that with a minor condition, if something is a minor condition, then the thing essentially is it's a warranty. So if something is a minor condition, it's a warranty. Based on that, it's a warranty and should lead to damages only. So generally, it has similar effect to the general contract. But here we are seeing that there's an introduction of a fundamental obligation. here, an introduction of a fundamental obligation. The fundamental obligation leads to what? Rescission and what? Damages. The fundamental obligation is something that has been implied by the Sale of Goods Act that no matter what, these are the things that the buyers and the sellers must do. No matter what, the buyer and the seller must do this thing before there are other conditions and warranties, and the ones also being set by the parties themselves. Now we have types of goods. The types of goods, you have specific, unascertained, existing, and future goods. They overlap sometimes. Now, specified goods or specific goods are goods that has been identified, set aside, and agreed upon by the parties before or at the time of the contract of sale. So most of the agreement that we make are for specified goods. I come to your shop, I see an item, I point at it, we make a deal on it, I buy it, I take it home. That item is a specified good. It's a specific good. It has been identified and what set aside at the time of the contract. At the time of the contract, for example, if it's a big shop, you are telling them to what move it and what bag it for me, and then what I pay you, I take the item home. So that's what a specific item. And then with an unascertained item, it is an item that has not been set aside at the time of the contract. And it is usually being sold by sample or description. I am from the village, far, far away. I have a mango farm. Now, I don't want to bring all my mangoes to Accra if I come and sell. So I could just take like 10 pieces of mangoes, bring it to Accra, come and show it to the traders and say, okay, I have mangoes. This is how the mangoes look like. So if you are interested, I could go and what bring you more. That is an unascertained good. At the time that I am describing the good to you, if you make a contract, the good is not present there. The goods have not been identified and set aside. It is after the contract that I will now go to the village and go and bring the mangoes to you. So that makes that what an unascertained good. So they're either sold by what sample. I can either bring you a sample, or I can come and describe it to you. That with the mango, when it arrives, it becomes yellow, full yellow, inside becomes yellow. When it takes, it's very nice. I come and what describe it to you. That makes it an unascertained good. Now, if an unascertained good now becomes set aside, then it now becomes what? Ascertained goods. So after we've made a contract, if we set it aside and I come and give it to you that, this is it, then it now becomes what? An ascertained good. So an unascertained good that has now been identified now becomes what? Ascertained goods. Now we also have existing goods and future goods. Now there are some goods that at the time of the contract, they are physically in existence and they are owned by the seller at the time of the contract. The goods are in existence, and generally all specified goods are what? Existing goods. All specified, because for me to be able to what? Identify the good and set it aside, the good must be what? In existence. So generally all specified goods are what? Existing goods. But sometimes existing goods could be unascertained goods. It could be. The goods may be in existence, but it may not be what? Set aside at the time of the contract. For example, I have a mango farm. The example I gave. The mangoes has been what? Severed, it has been baggaged, and it is there in the village. However, even though the goods are in existence, I am still what? Having what? It being an unascertained good, because at the time of the contract, the goods are somewhere, and then I'm having a contract with you. So we are saying that existing goods are in existence, but depending on whether it is at the place of the contract that is being identified and set aside, that will make it a specific good. And if it is somewhere else and we are making a contract here, that makes it an unascertained good. Now let's go to a future good. A future good is a good that is not in existence at the time of the contract. Now, for example, mangoes, I think they fruit twice a year. So I come and I tell you that, okay, so I have 500 mango trees. At least they produce 500 mangoes per season. Anytime that it fruits, it produces 500 mangoes per season. So if you are interested, we could make a contract, even though there are no mangoes on the tree at this time. We could make a contract, and if the mango comes, I'll just pluck every mango and bring it to you. We are making a contract based on a future good. The good does not exist yet. Or even if it's a product that I am now about to manufacture, we are making a contract on a product that has not been manufactured yet. That makes it a future good. But with future goods, usually it can only be what? Unascertained goods. So even though existing goods can either be specific or unascertained, future goods are what? Purposefully what? Only future goods are unascertained goods. Because of the nature of how a specific good should be. Specific goods must be identified at the time. So that means that if a good is future good, then it cannot be what? A specific good. So that's the difference. So we see that I told that there's a much overlapping between the goods. So we have specific which has been set aside at the time of the contract, unascertained, not identified, and not specified at the time of the contract. And when they become specified, they become ascertained goods. Now, existing goods are goods that has been existed. So they are in existence at the time of the contract. However, depending on whether it has been set aside or not, it will either make it a specified good or what, an unascertained good. And a future good is a good that is not in existence at the time of the contract, and it could only be what? Unascertained goods. Now, we distinguish between these goods because we want to know when property has passed. We make this distinction because we always want to know when the property has passed, because the types of the good is going to determine whether property has passed or property has not passed. And also we do it because sometimes we may go for remedies. Remember specific performance. And with specific performance, you could have a remedy for specified goods or ascertained goods, but it will be difficult and it is almost impossible to have a specific performance for what? Unascertained goods. Because the goods are unascertained. How do you seek for specific performance for unascertained goods? How do you seek for specific performance? The goods may not even be in existence. So how do you ask the court to force the person to perform as part of the contract by delivering the goods that are not in existence to you? So we split the difference because of these reasons. Now, transfer of goods. Now, with transfer of goods, we split the goods into three. We have specific goods and then we have unascertained goods. Now, when do we say a specific good has been transferred? When do we say a specific good has been transferred? Now, property, that's ownership with a specific good, passes at the time that the contract parties intend for it to pass. So it may be determined by the terms of the contract, the conduct of the parties, or the circumstances of the case. Now, when the price is paid, sometimes when the price is paid, it is presumed that, hey, the goods has passed. Whether and when an event occurs or not, it can be inferred that the good has passed. When a replacement is done, when the buyer immediately takes delivery, and when all owns are paid. So depending on the terms of contract, the conduct of the parties, or the circumstances of the case, we could imply that what the goods intend to pass. But the idea is that when parties intend for the goods to pass, the goods has what? Passed to the other person. Now, in the absence of the intention of the parties, we say that when goods are delivered, property has passed. When I deliver the goods to you, if it's a specific good and I deliver the goods to you, we are saying that property has passed. Now, usually we look for property passing because we look at who bears the risk when there is a fault with the good. Or when the goods get destroyed, who bears the risk? That is why it is very important to know when property has passed in all the types of the goods. Because if we do not take care, it will be difficult to look at who bears the risk when there's a problem. There is this example that people usually say that if you're buying a goods and then you go to the market, you're buying the goods, and then as you were giving the goods as you're giving the money to the person, the goat jumps and then the goat chews the money. Who is liable? Do you get your money back or do you take the goat home? You are buying a goat. You receive the risk. That is why we determine who the property has passed to and who the property has not passed to. I want to reminisce on this. At the end of the class, we will discuss who bears the cost of does the owner keep the goods or does the buyer keep the goods? The seller or the buyer who keeps the goods. And who has to pay the other party for the damages caused. So this was specific goods. We are saying that when the parties intend that the property should pass, property has already what? Passed. And the intentions could be judged based on the following. Now let's go to unascertained goods. We are saying that with unascertained goods, property passes when the goods have been ascertained. So if you have an unascertained good, property would pass if the goods have now been set aside and identified. That is where it has become what? Ascertained. Now, if ascertainment has not taken place, the buyer is guilty of what? Stealing if he tampers with the goods. So even though we've made an agreement that if my mango fruits, I'm going to give the mangoes to you. That doesn't mean that you could come to my farm and come and do whatever you want. If the mango is fruiting and you come and tamper with it, I can accuse you of stealing because the goods has not yet been ascertained. Even though I have a contract with you, the mangoes must fruit. I must pluck the mangoes, and then what I must identify and set it aside. Okay, this is your mangoes. Come for it. That is where you can come
There's
for
a
your
lot
mangoes.
of break, we can't hear anything.
Hey, I've been speaking. Who else is having this problem? Is it only Samilia or everybody's having this problem?
I can hear.
Okay, so Samilia, if everyone can hear me but you, then it might be your network. All right. All right, thank you very much. So if everyone but Samilia, then it means Samilia, it is your network. All right. So yeah, I'm saying that if it is an unascertained good, you have to wait for it to be ascertained before you can tamper with the goods. If it's not ascertained, it doesn't matter the contract that you have. It doesn't matter even if you pay the amount. It doesn't matter. All we need is that if you tamper with the goods before ascertainment, it can amount to stealing. So we are also saying that here, because property has not passed, if the farm gets burnt down, you don't have any risk because property has not passed to you. You don't have any risk because property has not passed to you. So that's the idea behind it. Because you don't have the risk, when something bad happens to it, then you don't get the benefit of what? Tempering or what? Enjoying it until it is what? Ascertained. And then we have another good, which is known as goods delivered on sale or return basis. Goods delivered on sale or return basis. Now here, this is where sometimes a seller can deliver goods to you and tell you that, hey, I have these things that I have these things that I think you might be interested in. I am sending them to you. If you are interested, keep it and sell it. But if you're not interested, send my things back to me. That is what goods delivered on sale or return basis. So if you're interested, I'm selling it to you. If you're not interested, just send my item back to me. That is what goods delivered on sale or return basis. So here the goods are delivered to a person to buy where they are yet to enter into a contract of sale. I've delivered the goods to you. You have to decide whether you want it or you don't want it. Now, upon approval or agreement by the parties, a contract may arise between them. Now here, we are saying that if the property passes under the following circumstances. One, when a buyer ought accept it. So if the buyer says, hey, I'm interested, give it to me, I'll keep it. Then what? It means there's a contract between the parties. Or when the buyer does an act to adopt the transaction. So when you do the act to adopt the transaction, so I give an item to you, you do not explicitly tell me that you want it, but I give the item to you, and then you also start selling the item. I have trade clothes, second-hand clothes that I deliver to people. Now you sell items in the market. I come and give the goods to you that look through if you're interested. Can what also start selling and I'll come for my money. Now you can either call me and tell me that hey, I'm interested in the goods, so I'm going to keep it and sell it and give you your money. That is one. Or even if you don't call me and then you start selling the item, you do an act that signifies adoption, then it means that I can come for my money. We have a contract. But if there is no approval, then adoption is what can be implied when there's what a stated time or when it's a reasonable time. that will mean that I'll tell that, hey, if you're not interested, just return my goods within 1 week. If you do not return the goods within 1 week, it means that what? You want the good. Or even if I don't state the time, the reasonable time, depending on whether the item is perishable or not, depending on the circumstances, you can infer that you want adopted it or not. Here, if you do not want to adopt it, explicitly tell me that you do not want the product. That is one. Or two, return my goods to me. If you don't do that and any of these things apply, it will be assumed that you've accepted to enter the contract with me, and then I can come back for my contract price. Now we have transfer of risk. Now, risk refers to the danger of loss, damage, or deterioration of a good, which are what the subject matter of the contract of sale. Unless otherwise agreed, the goods remain at the seller's risk until the property has been passed to the buyer. So generally, property passes to what's risk. That is the general idea. So unless otherwise agreed, the goods are with me, or the seller keeps the risk of the good until the property is passed to the buyer. That is why it is very important to distinguish the goods and the what when property passes. So with the specific good, we are saying that property passes when the parties intend, and the intentions could be when I take delivery, when I pay the money, when we exchange the item. It could all amount to what? The intentions. Now, with the unascertained goods, we are saying that property only passes when the item becomes ascertained. That means when the item is identified, that is where the property passes to. So, under those circumstances, like the example I gave, if the mangoes are yet to fruit and the farm gets burnt down, the risk remains with the seller because property has not passed to me. Even though we have a contract, property has not passed to me yet because the goods have not been identified. So we say that generally the goods remain at the seller's risk until property has passed to the buyer, after which they are at risk whether delivery has been made or not. So when property has been passed to you, you are at risk of losing the property. Now the following rules apply. One, the risk in the goods is transferred to the buyer at the date when the properties intend for it to pass. That is one. Two, where there is no such intention, risk generally passes at the time that the property passes. So the people can say that, okay, so even though property has passed today, risk passes maybe when the item is delivered to you, that is tomorrow. That is one. But if the parties keep quiet, then generally, property passes with risk. Generally, property passes with risk. Now, when there have been delay in the delivery, then the party responsible for the delay is made to bear the risk. When there is delay, the property, the party responsible for the risk, the party responsible for the delay bears the risk. Now, where any party is in possession of the goods, he is expected in his capacity as a bailiff to take responsible care of the item. Otherwise, he will be responsible for the loss. Now, I have bought an item, even though risk has passed to me. If the item is in your warehouse, you must make sure that you protect my item for me. The fact that property and risk has passed to me doesn't mean that you should handle my item anyhow. And sometimes, if there are insurance to be, if the owner is taking insurance, then the insurance can take care of the risk. However, if you do insurance, you realize that insurance companies can also go after parties who have caused the harm. So after indemnifying, the insurance party cannot go after the insurance company can go after the party who has caused the harm. Now we have duties of a seller. Now, here duties of a seller are more than the duties of a buyer, because generally the seller is the one who has to do most of the things. The seller just has to pay money and take delivery. So the duties of a seller as to the quality, the quantity, all of these things falls on the seller. Now, the fundamental obligation of the seller, the fundamental obligation, this one is non-negotiable. Is the fundamental obligation. Now, it is the fundamental obligation of the seller to make sure that if it is a specific goods, then it is his fundamental obligation to deliver the goods. Specific good, it is your fundamental obligation to deliver the goods. Now, if it's an unascertained good, then it is your fundamental obligation to make sure that the goods substantially correspond to the description of a sample by which the goods were sold. You can't tell me that the mango has a circumference of 50 centimeters, and they bring the mango and then they are what? Just 10 centimeters. The circumference is just 10 centimeters. They are small mangoes. No, I can reject that. So with the unascertained goods, it is the fundamental obligation of the seller to make sure that the goods substantially. So if you bring me mangoes and the mangoes are, let's say, 50 centimeters, has the circumference of 50 centimeters, and then you go and then the mangoes that you bring, some are 48, some are 49, some are 50, some are 51. You know that fruits cannot have what? The same sizes. At least that makes sense because it substantially corresponds to the description of the sample that you brought me. However, if you brought me 50 centimeters and then I'm getting 10, 11, 15, it does not substantially correspond to it. Now, we are saying that any provision in the contract of sale which is inconsistent with or repugnant to the fundamental obligation of the seller is void to the extent of the inconsistency or repugnancy. So if you want to take out this fundamental obligation, it is impossible to take it out. It is something that the seller must do, even if there is an exemption clause to this effect. The exemption clause is not going to work because this is a fundamental obligation. So if there's an exemption clause that you would have to accept anything that I bring, that exemption clause is not going to affect it because of this clause in the Sale of Goods Act. It is telling us that this is a non-negotiable. So because of that, if you have any clause that is repugnant to this, it is not going to hold. It is your fundamental obligation to deliver the goods if it's a specific good, and also it is your fundamental obligation to make sure that the goods substantially correspond to the description of the what or the sample. Other than that, you can just describe something that is very nice to you. You deliver it, and then the thing is what way different, just because they made a disclaimer. No, if it's an item that is what an uncertain goods, they cannot do that. Now, another duty of the seller is to make sure that the goods exist and he has the right to sell the goods. So if it's a specific good, there's an implied condition that the goods exist. For a future good, that's a different thing. But if it's a specific good, there's an implied condition that the goods exist. And if there's any kind of good, then there's an implied warranty that the seller has the right to sell the goods. At least you have the right to sell the goods. And then we have quality. So the quality of it, we are saying that here, if there's a sale by description or sample, in a sale of a contract by description, whether or not the sale is by sample or by description, there's an implied condition that the goods shall correspond exactly to the description. And if it is a sample, it will be what? There's an implied condition that the goods shall correspond exactly to the sample. That's the quality of the good. If you're looking at the quality, you are telling me that this thing works this way, then there's an implied condition that it works exactly that way, especially if it's by description or sample. There's a machine, you are telling me that when this machine mills your maize, it is going to be like powder. It is going to be like fine powder. It's going to be like fine powder. If I come and then it doesn't do that, I can what? Sue you because there's an implied condition that at least the quality of the good should correspond exactly to the description that you are giving me. Now we have quality and fitness. Quality and fitness. Now, generally, there are no warranties or conditions to the quality of fitness for any particular purpose of the good except the following. So generally, we are saying that there is no implied warranty or condition. However, there's the implied condition that goods supplied by the seller shall be free from any defect declared or known by the buyer before the time of the contract is made. So generally, if you are giving something out, the quality is not of what? the quality is not something that you should care about. But there are certain things that, even though the quality is not something that you should care about, there are certain things that the sale of goods have pointed out that are very important, that are even in the same thing as the quality. So sometimes people even view this phrase as something that is not holding enough, because even though they has made this statement that there is no impaired condition to quality, they've made statements to some effect that if it falls within it, then there will be the impaired quality, impaired condition. For example, defects. So as a seller, you do not have it is no obligation to make sure that something works. However, if there's a defect, then you would be held liable. So we are separating the fact that the thing doesn't work as it is supposed to be from if there's an actual defect on the item. So here we are saying that there's the implied condition that the goods are free from defects. Now, this can be waived under the following circumstances: where the buyer has examined the goods and the goods should have revealed itself. So if the seller gives you the chance that, hey, come and then come and go through the goods and see whether you see any defects. If you are given the opportunity to do so, and you do it and then you don't do it well and there's a defect, the seller is not going to be held liable. To where the buyer, in case of a sample, has examined the sample in respect of defects, which should have been revealed by the examination of the sample. You've examined the sample, you didn't find any defect, and they bring you the same sample, the goods based on the same sample, and there's a defect. You cannot blame them, because you were given the opportunity to actually go through the sample. However, if it is different from the sample, then you can sue them. But if they gave you the same sample and didn't find any defect and they deliver everything to you, you cannot go back on your word. Now we are saying that if you're not given the opportunity to inspect the item, then there is a implied condition that it will be free from debt. But if you are given the opportunity to inspect the item, and then the item corresponds to whatever you are being given, and then you're given the opportunity to, then now the burden now falls on you to find the defects. Now, where any specific defect has been drawn to the attention of the buyer, I tell you that, as for my car, the brake, you'd have to stamp on it very hard before the car stops. If you still want to buy the car, fair enough. I have already told you that the brake has a problem. So if I have told you that the brake has a problem and you continue to buy, then I do not have any obligation to you again. And then next, where the seller does not sell that type of goods in the ordinary course of his business, and the defect is such that it could not reasonably have been aware of it. So sometimes you are selling something new, or you didn't know the item, so you didn't do something on purpose. You actually didn't know. Then sometimes the law can give you a leeway, and you would not be held liable for defects. Now, even though an item, the seller is not bound by the fact that the item should be fit. If the buyer tells you that he's going to use the item for a particular purpose, so he should fit the particular purpose, then there's the impaired condition that what you are giving the person should actually fit what the person is going to use it for. So if I tell you what I'm going to use the item for, then everything changes. Then here you must give me something that could actually work for the item I'm doing. So for example, I need which example can I give? I have, let's say, poultry. I have poultry in the air. I have poultry at home, and then the poultry that I have at home, they've hatched. They are babies. Now, I came to you that I am looking for feed, and the feed should be able to make sure that I'm able to take care of my item, or I am able to it's able to make sure that my poultry grows. Now, if you provide goods for me, and the feed that you give me is for elder poultry, like poultry who are old, and then it ends up killing the babies, I can sue you because I have told you specifically that I am going to use this feed to I'm going to use this feed for my what poultry, and then the poultry is very what young. So if I indicate what I'm going to use it for, I'm buying a headache drug. I'm buying a drug for headache. I tell you that I am allergic to caffeine. I'm not supposed to take caffeine. So I need a pain reliever that does not contain caffeine. You go ahead and you assure me that this pain reliever does not contain caffeine. I take it and then I get the head. I can sue you because it is not fit for the purpose. I explain to you that I don't take caffeine, so I don't need something that has caffeine in it. So if I explicitly tell you the purpose of the item and what you give me is not fit for that purpose, then you've breached an implied condition that I can sue you. Now, quantity of goods. Now, when you deliver quantities to me, there are at least 5 situations where this can happen. Now, if you deliver less quantity to me, I can either accept or reject it. I want 100 pieces, you give me 80 pieces. I can decide to either accept or reject it because it is not up to the 100. Now, if you deliver more than the quantity, you give me 120, I cannot reject, or I would have to accept the 100. And then for the 20, I would either, for the 20, I would either choose to accept or reject it. If I accept it, I pay a reasonable price. But if I reject it, then I can sue you for damages for what? Separating the items and resending the thing back to you. So if it is less, I have the right to either accept or reject it. But if it is more, then I would have to accept the 100, but what choose between the 20. So if I need 100 and give me 80, I can either accept or reject it, the 80. But if you give me 120, I would have to accept the 100, but additional 20 to depend whether I would accept or reject it. If I accept it, I'll pay a reasonable price. I'll pay the contract price for the 20. However, if I choose to reject it, then I can sue you for what? The cost of separation of the items. So we are saying that if it is less, you cannot reject. If it's less, you can either accept or reject. But if it is more, then you would have to accept the contract quantity, and then the rest you choose what to do with it. Now, when you deliver 2 different items, and they are all less than, I can choose to reject all. I need 100 bags of rice. You give me 80 bags of rice and 20 bags of maize. I need 100 bags of rice. You give me 80 bags of rice and 20 bags of maize. I can reject everything because I do not need 80 bags of rice and 20 bags of maize. I need 100 bags of rice. So with this one, if it is less, that is 80 bags of rice and 20 bags of maize, I can either choose to accept the rice or reject the rice. Or I can choose to accept the maize or reject the maize. Here, I have the option to either accept or reject all of the items. I have the option to either accept or reject. And if I accept only the 80, I can sue you for the rejection of the 20 bags of maize, because I would have to separate it. For example, their bags, I would have to hire people to take it out of my shop and separate everything. I will sue you for the means for separating the items. So here we've done, if you give me less quantity of the item, I can reject. If you give me more quantity of the item, I cannot reject. I would only have to accept the part of the contract quantity, and then the rest I can either accept or reject it. Now, if you give me 2 different items mixed, I only ask for one, but you give me 2 different items mixed, and then they are both less than what I asked for, I can reject or accept them. I have the option to either accept or reject them. Now, if you give me mixed products, but it is exactly what I ordered for, and then the other product is what just added to it, I would have to accept the contract item, and then the rest I can choose to accept or reject it. So this example is where I asked for 100 bags of rice. You give me 100 bags of rice, and then you add 20 bags of maize to it. Here, I do not have any other option than to accept the 100 bags of rice, because the 100 bags of rice are up to, I would have to accept the 100 bags of rice. However, with the 20 bags of maize, I can choose to accept or reject it. Now, if I accept it, I would have to pay a reasonable price for it. But if I reject it, then I would have to sue you for the cost of the separation of the maize from the rice. Now, another instance is where you give me more than what I asked for, and also add something else to it. I wanted 100 bags of rice. You've given me 120 bags of rice plus 20 bags of maize. Here, because it is more than, I would have to accept the 100 bags of rice. And then the extra 20 bags of rice and the 20 bags of maize, I can choose to either accept and pay a reasonable price or reject it. If I accept, I pay a reasonable price. If I reject it, what I need to do is that I need to sue you for the cost of what? Separation. So the idea is that I can only reject when the contract quantity is less than what I agreed for. But if the contract quantity is exactly or more than, then I would have to accept the contract quantity, and the rest I can do whatever I want with it. So the only time that I can reject all the items is where the contract quantity is less than what I asked for. That is the idea. So with all the combinations, when you go through, you realize that the only time that you have the right to reject everything is when the contract quantity is less than what you asked for. Now, we still have these steps. We have delivery. Now, the delivery, we are saying that unless otherwise agreed by the seller, the delivery will take place at the time that there was, in exchange of the money concurrently. So I give you the money, you give me the delivery of the item, unless otherwise agreed by the parties. Now, anytime that the act contains this provision, that unless otherwise agreed by the parties, that means that the act has given the parties the right to decide otherwise. Other than that, so this is what an implied an implied term by what statute. And an example is this. So they are telling you that unless otherwise agreed by the parties, then it means that the act has given the parties the chance to choose. But if they don't choose, this is where they would imply that then money must go for the good. That's ineffectual unless it is made at a reasonable hour. Now, if you tender the delivery to me and then it is not at a reasonable hour, I can reject it. So the time of delivery is also very important. Now, the cost of delivery. Now, unless the parties agree otherwise, unless there's a contrary intention, the seller bears the expenses of what? Putting the goods in a deliverable state. If I buy an item and you are boxing it for me, I don't pay for the box. That's the general idea. But some companies really sell the item. If you want us to box it for you, you have to pay. If reply otherwise, they said, okay, as for my shop, I don't box for you. If you buy, the boxing will have to what? Take extra cash. But if there is no contrary intention, there is no contrary agreement, there's a contrary intention, the place of delivery will be the seller's place of business. That is what that's what we usually do. When I buy an item, I go to the seller's place and I go and pick it up. The business I go and pick it up. Now, if the seller doesn't have one, then we go to his residence. So it's either his place of business or what his residence. Now, here we say what? Unless otherwise agreed by the parties, unless a contrary intention appears. That means that the seller can decide to deliver at the buyer's house. But the general concept is that if they do not decide that, or they do not decide at a different place, then the idea is that the delivery will be at the seller's premises, or it will be at the seller's business place. Now, provided that in a contract for the sale of goods, which to the knowledge of the parties, when the contract is made some other place, then subject to any contrary intention, subject to any contrary intention that the place of that the place might be the place of delivery. So for specific goods, if the goods are identified, so if I have a place of business, but I bought the goods to a neutral location, and then we are making the contract on a specific good, then the idea is that the place that the goods are will be the place of the delivery. That's the idea. Even though it is not my business place, where I have it will be the place of the delivery. So we are saying that provided that if in a contract for the sale of specific goods, which the knowledge of the parties, when the contract is made, are in any other place, then subject to any contrary intention, that place is going to be the place of delivery. So if one, I don't have a business premise, or I don't sell for my residence, and I bring it to a neutral location, and then we make the contract, exchange can take place at the place that we are making a contract, which is not my premise. Now, time of delivery. Time of delivery. Now, this is very simple. The idea here is that when we fix a time, you must deliver within that time. If there's no fixed time, you must deliver within a reasonable time. If it is something that I told you that is very urgent, they need to deliver it on time. As we've already discussed, reasonableness depends on what? The circumstance of the contract. Now, parties may also decide to what? Stipulate a new date for the delivery. I call, hello, oh, I may not be able to make it. Say, oh, fair enough. When can you make it? You can decide on a new date to make it. Now, if we decide on a new date to make it, then you must deliver on the new date. But if we postpone and then we do not actually specify the new date, then you have to deliver within a reasonable date. Sometimes the seller will tell you that he will use his best endeavor to deliver the goods. And if he says that, then he must deliver within a reasonable time. Here, the whole idea is that if there's a fixed period, just deliver within a fixed period. If there's no fixed period, deliver within a reasonable time. Parties can also choose to change the date of delivery. And if you say you use your best endeavor, make sure you deliver at a reasonable time. Now, we also have means of delivery. When can we say there is a means of delivery? Now, unless otherwise agreed by the parties, the means of delivery may be the following. One, when I transfer the actual physical control of the items to you. So when I give the actual physical control of the item, I've delivered the goods to you. Or when I transfer the means of obtaining actual physical control, I give you the keys to the item. I have transferred the item to you. I give you, so for example, the item is in a storage closet. I give you the keys to the storage closet. It can be seen that I will made delivery to you. So it's either I give the item to you that take, or I give you a means to it, the keys to it. Or if I transfer the documents to you. So any of these things could imply delivery. You buy an item, you buy a car, the cars will be given to you yet. But I give you the documents registered in your name, delivery has been made to you. So if I give the actual physical item to you, or I give you a means of obtaining the physical control of the item, or I give you the documents to it, I have transferred to you. You can also choose otherwise. You see here, we're saying that unless otherwise agreed, so the parties can agree otherwise. Okay, so we can only say you've agreed, you delivered it to me when something else happens. That could also be it. But outside that, the court is going to apply these three as the test. Now, also, unless a contrary intention appears, delivery of goods to the buyer's agent or to his order is delivered to the buyer. Here we have agency playing a role, but the agent must be an authorized agent. So if I deliver to an authorized agent, or I deliver to a place that you've told me to deliver to, it will be as if I've delivered to you, the buyer. Now, also, unless a contrary intention appears, delivery of goods to a carrier pursuant to or consequence upon the contract of sale for transmission to the buyer is delivered to him. If I deliver to a carrier or a delivery person, it will be as if it has been delivered to you. Now, unless a contrary intention appears, that means I can say that hey, because the delivery man is not mine, it is yours. If the delivery man doesn't get to me, I've not received the goods. That is fair enough. But the general idea is that delivery passes when I make delivery to a carrier pursuant to or consequence upon the contract of sale for transmission to the buyer, then it is delivery to the buyer. Also, where goods are in possession of the third party, They are delivered to the buyer when the third party acknowledges to him that he holds the goods on his behalf. So if I'm selling an item, but the item is with what? A third party. And then the item, and then the third party tells that, hey, the item is with me. So either come for it or I'll come and give it to you. Now, if the third party tells you that, then it means that what the delivery has been made to you, because I have made the third party what notify you that the goods are with him and then what you should come for the goods. Now, dispatch by a carrier when you give the item to the carrier. Now, where in the conduct of sale, a seller is authorized or required to send the goods to the buyer by carrier, then the implied condition is that the seller shall make such contracts with the carrier on behalf of the buyer as may be reasonable and having regards to the circumstance of the case. Unless otherwise agreed, where goods are sent by the seller to the buyer by routes involving sea, air transport, or circumstances in which it is usual to ensure the seller must give such notice, or if any, as required, as may be required by the buyer to enable him insure the item during the sea or air transport, as if the seller and if the seller fails to do so, the goods shall be at its risk during the transit. So if I'm dispatching the goods by a carrier, I must make sure that if it can be insured, I will tell that I am insuring it so that if the goods get destroyed, I will take the insurance money and the what, maybe refund you. If I don't do that, then the item is what at my risk. Now, duties of the buyer. The duties of the buyer are just two. The fundamental obligation of the buyer are just two. One, pay the price, and two, accept delivery. That is all the buyer has to do. Pay the price, accept delivery. That is all you have to do as a buyer. So when you are asked duties, fundamental obligations of the buyer, the fundamental obligation of the buyer is just to pay the price and what, accept the delivery. That is the two fundamental obligations of the buyer. For the fundamental obligations of the seller, for specific goods, he must deliver the goods, and for unascertained goods, he must make sure that what the goods that he submits is what corresponds substantially to the what sample or description. These are the two fundamental obligations of the seller. The rest are what other obligations, which can either be what conditions or warranties. And then when it comes to the buyer, we are saying that the fundamental obligation of the buyer is to one, pay the price, and two, accept delivery. He may refuse to do these things when the seller has also what breached any of his fundamental obligations or what conditions. Because you cannot tell me to accept delivery if there's a defect. So even though it is an obligation, you can refuse to do it if the seller has first what breached any of his what obligations. Now, also payment should be concurrent with delivery. Anytime that there is delivery, I should pay you, unless what there's a contrary what agreement that hey, even though I am I'm delivering the goods, and if you're delivering the goods to me, I would want to pay next 2 weeks. That is what a contrary agreement. Now, time of payment and what accepting delivery, unless otherwise agreed by the parties, the time of payment and the time of acceptance are not conditions of the contract. So unless otherwise agreed, stipulations as to the time of payment and as to the time of accepting delivery, they are not. Unless otherwise agreed, as to the time of payment or the time of accepting delivery are not conditions to the contract of sale. And then buyer is also not bound to accept delivery by installment. So unless otherwise agreed by the parties, buyer is not bound to accept delivery if the goods are made in installments. So like I said, anytime that you see unless otherwise agreed by the parties, then the parties can agree otherwise. But with the fundamental obligations, they are not otherwise. With the fundamental obligation of both the buyer and the seller, it is something that it is something that they have to what obey and something that they have to go by. Other obligations, sometimes they can give them leeway for them to what imply otherwise or what agree otherwise. But when it comes to the fundamental obligation of the buyer, fundamental obligation of the seller, they would have to what go by it. Now we have rights and remedies of the unpaid seller. So it can be rights or it can be remedies. Now, if a seller is unpaid, I am unpaid. Now he has two types of rights. He has real rights and personal rights. Real rights and personal rights. Now the real rights, if he has not been paid, he can have a lien over the goods. So he can keep the goods until the buyer pays him. We've agreed that you would pay me, then I'll deliver. You've not paid me, the goods are with me. If you don't pay me, I don't deliver the goods to you. So he has the right of laying over the goods until the buyer pays him. And then we have right of stoppage in transit. If the goods are in transit but haven't reached the buyer, and then there's the intention that the buyer will not pay or cannot pay, he can stop the goods. He can stop the goods and return the goods back to him. And then we have a right to recover possession. If the goods has already gotten to the buyer, if the goods has already gotten to the buyer, he can go and repossess the goods. Especially if the buyer doesn't want to pay or the buyer cannot pay, he can go and repossess the goods. And after all that, you have the right to also resell. So here it is in steps. If the goods are with me, I'm not going to deliver to you until you pay me. If the goods are in transit, I can stop the goods in transit. If the goods are with you, I can come back for my goods. And if, for example, you are bankrupt or you don't want to pay or you cannot pay, I can also resell the goods to someone else. These are the real rights of the unpaid seller. And then the personal right, you have the right to sue for the price. So the goods are with you, you don't want to pay, you have the means of paying and you don't want to pay, you can sue you to recover the price. And also he has the right to bring you an action for damages for non-acceptance. He has gone through all of the process and you don't want to accept it, and he can sue you for non-acceptance. You don't want to accept the goods, fair enough, I'll take my goods, but I'll sue you for wasting my time. I'll sue you for damages for non-acceptance. So if you are asked to state any rights or remedies of the unpaid seller, I can just mix it and just write any of these as the rights. However, if there are specifications that, okay, so what are the real rights, then you only have to state the real rights. And if they ask what are the personal rights, then you only have to state the personal rights. Now, buyer's rights. The buyer also has real rights and personal rights. Now, the buyer's real right is only one. He has the right to reject the goods. That is his real rights. And these rights are under certain circumstances. One, when there's a breach of a fundamental obligation. So when you breach a fundamental obligation, if the goods that you are bringing him doesn't correspond substantially to the sample that he described, he can reject it. So if the seller breaches the fundamental obligation, the buyer also has the right to reject delivery. So if there's a breach of a serious condition, he can reject it. Also, you remember visitation factors. If there's a visitation factor involved, misrepresentation, fraud, all of those things, you can also reject the goods. So you lied to me about the product, about the specification of the product. You brought it to me, the product doesn't correspond to it, I can reject it. If you misrepresent or if there's a fraud, I can reject it. Here we are saying that the buyer has the right to reject the goods. That's his only real right. But I'm breaking it down to make you understand that these are the circumstances where the buyer can reject the goods. And then the personal right, we have recovery of price. I've rejected the goods, give me back my price. He has damages for non-delivery. I've made a contract to you, you've not delivered the goods to me, I can sue you for damages for non-delivery. Also, a right for a breach of a conditional warranty. So if you breach a conditional warranty, I can also sue you for damages for a breach of conditional warranty. And also I can sue you for specific performance. You remember specific performance and a general contract. Since this is a contract of this is also a sale of goods, which is also a contract, I can sue you for specific performance. So these are the buyer's rights when it comes to a contract of sale of goods. Now we go to the last thing that we will do and then we'll close. This is the Nemodat rule. The Nemodat rule. Now this idea is, you remember that there is the seller's rule that, or there is the idea that the seller must either own the item or have the right to sell the item. That is where the Nemodat rule comes in. So the Nemodat rule says that no one can pass any title that he does not possess. I cannot sell something I do not own. That's a general idea. If I don't own something, how do I transfer ownership? So the full maxim is Nemodat con non habet, which means that no one can give what they do not have. If I don't have something, how do I transfer ownership to you? How do I give something that doesn't belong to me to you? Like the account say, quarter amount to man. Patrick, you have nothing. How can you give something that doesn't belong to you to somebody? So I cannot give something that I do not have. So at common law, the buyer is responsible for the deficiency in a contract that he enters into. That's what caveat emptor. If you buy a stolen product, the owner can just come and take it from you because you are not an innocent third party purchaser. So we have the caveat emptor where the buyer must be careful. Now, an extension of the caveat emptor is the nemo that rule. Now, that is whenever a seller has defective title in the goods, the buyer also obtains a defective title. If I do not have a full title, if I have a defective title and I transfer the title to you, you also have what? A defective title. So if the real seller comes, the real seller can come and take the item from you and what? You go away. And now you'd have to come and look for me, and maybe at that time I'll be long gone. You'd have to come and look for me to what? Recover your money from me. Now, the real owner can maintain an action against the seller for what? Wrongful sale. Now, the drawback is that it creates hardship on innocent third parties. So the name of that rule was creating some hardships on third parties. That is why we said what? Protecting the third party purchaser or the innocent third party purchaser. Here, it must be what? Innocent, it must be a third party. So when you buy an item and then you are innocent in a third party, the law might side with you because if you side with the original owner, it might be what? Wrong to side with the owner because it will create hardship on you who was innocent and then what? You bought the goods. So they realized that the name that tree was kind of what? Restrictive and it was causing hardship on people who bought things genuinely with their money and then they will lose their money. So because of that, they created exceptions to the name of that tree. Now, sometimes, even if you buy something from someone and the person doesn't own it, you get to keep the good. Even if I buy something from you and then the item doesn't belong to you, I still get to keep the good. So let's go through the exceptions quickly. So one, where the doctrine of estoppel applies. You remember estoppel? When you lead people to believe something is true and they rely on it, they cannot go back to it, or they cannot go back on their word. If I tell you that, oh, as for this girl, if you see her, you've seen me. So anytime that she does something on my behalf, just assume that I'm the one who did it. And then the person takes my item and sells and then sells it to the person. I cannot go to the person and go and take the item back because the person has relied on what I said and then what the person has bought the item from the lady. Now, also, any power of sale conferred by any enactment. Some enactment has given certain people the power to sell certain things, even though it doesn't belong to them. So you can have the forfeiture of asset decree during the military government regime, and then you can even have SEPs, customs, and then I think it is customs and something department and protective services department. When they seize your item, they can sell the item, even though it doesn't belong to them. You go to the ports, they ask you to come and pay your duties, don't pay your duties, even though the items do not belong to them. If it reaches a certain point and don't come for it, they can auction the item and they can sell it. If you see someone driving a car that you imported, you cannot go and take the car from the person just because the person didn't buy the car from you. Now, even though the person didn't buy the car from you, some enactment has given the people who sold the car to him the power to sell it because you've not come for your item or you failed to come and pay your duties to come and take your item. So we are saying that certain people have been given powers by enactment. And when people buy items from them, they can keep the item. So even if you import something, you don't pay your duties, and then you realize that someone is using your item or the item is with someone, cannot go to them because the one who sold the item to them has been empowered by an enactment. And then we have judicial sale. Judicial sale, if there is a judgment, and then the judgment means that you don't have any means of actually paying the item. You have a land, and then the judicial gives powers to someone to go and sell the land to defray the debt. If the person sells the land to someone else, the person has the right title to the land. So if it's a judicial sale, even though you're not the one, or even though you don't want to sell the item and you're not the one who sold the item, if it is a judicial sale, the person would have to keep the land because it is a judicial sale. It came out of what? A judgment. And then next, we have deposition by a mercantile agent. You remember an agent can do things on your behalf. So if an authorized agent that is giving goods to sell on your behalf sells the good, then the property passes. Even though you are not the actual person who sold the good, a mercantile agent who sells it on your behalf that you've given the person the authority to do so, if he sells it, the person gets to keep the good. Now we have sale in a market overt. Now, a sale in a market overt is what? An open market where what? There's a legitimate market going on. So if you go to, let's say, a place where we sell goods for this aid that they are doing, a place that they sell goods, and then there's a stolen goods involved in it, and then you buy the goods and send it to him, and then someone who's the owner sees it and the person wants to take it. The person cannot take it because you bought it from a market overt. You bought it from an actual market where they sell goods. So a market overt is where goods are sold in an open market according to the usage of the market. The buyer acquires a title to the goods provided they acquire them for value in good faith and without notice of the defect in the seller's title. You see a lot of people selling goods, so it is good to assume that everyone selling the good there at least has the right to sell the goods. So if you buy the goods from them and you send it to them, and then someone comes and is the good, the person cannot take it from you. And then we have pledged property. Now, when goods are pledged within a certain period of time, the pledgee can sell the pledged product within a specified time. You come and pledge, you come and take a loan from me, and then you pledge, let's say, an item with me that within a year you come and pay, and then what? You take your item back. If it is within a year, you don't come and pay it, I can just pawn it off to defray my debt. So even though the item doesn't belong to me as a pledgee, if you come and give your item or you come and pledge your item with me, and you don't come and redeem the pledge, I can sell your item to someone else. And the person would acquire what? A good title, not a defective title, just because you have what? Failed to what? Come and what? Redeem your pledge. And then we have sale by joint owners. Now, we sell by joint owners, sometimes an item can be owned by two or more people. So if A and B owns an item, and then B knows that the item is with A, if A sells it to C, even without B's notice, C gets to keep it. Because here we are saying that A has joint ownership with B, and then B knows that the item is with A. So always must know that if he doesn't take care, A can sell it. So even if he sells without A's notice, because if A sells without B's notice, because A has joint ownership, C would have to what? Keep it. So here we are saying that when goods belong to several or joint owners, and one of them sells same, the buyer acquires better title if joint owner, the seller, is in possession of the good with the consent of the co-owners, and the buyer acted in good faith without notice of the lack of authority to sell. So where they are joint owners, you get to keep it if the other owners knew that the item was with the person and you didn't know of any wrongdoing. And we also have sale by a person in possession of a good in a voidable contract. Now there's a voidable contract. The contract has not been voided yet. It is voidable, but it has not been voided yet. So if at the time that the person sold it to you, the contract has not been voided yet, and you also acquired it in good faith, you get to keep the item. So you are saying that buyer gets to keep it when at the time of sale, the contract which the seller obtained the good has not been rescinded, that it has not been voided. And then the buyer also acted in good faith without knowledge of the voiding. And then we also have sales by a buyer in possession of the goods after agreement to sell. Now, we have an agreement to sell, and the goods are with you, but we haven't sold the goods yet. We are negotiating that I want to sell this phone to you. Fair enough, I give the phone to you for you to check out the phone. We've not agreed exactly that the phone is now yours, but the phone is with you. You are checking the phone that the phone works, see whether the phone works. If you sell the phone to a third party, the third party gets to keep the phone. Because what? You are a buyer and then what? You are in possession of the good. So you are saying that where a buyer obtains possession of the goods before title passes to him, and he resells or he pledges the goods. So if he resells or he pledges the goods, we are saying that the third party would acquire better title if he acted in good faith. So the buyer are giving the good to you to just check it, but you end up what selling the item. So even though there's an agreement to sell, property has not passed to you yet. Even if you sell it, the third party gets to keep the goods. Or if you pledge it, the third party also gets to what keep the pledge. And then you also have sale by seller in possession after sale. Here you sold the item, property has passed, but the possession is still with the seller. Now, if the seller sells the good to someone else, that person gets to keep it, and then you would have to deal with the seller yourself. So here we are saying that in a situation where a buyer has purchased the good, but the same remains with the seller who resells the goods to a new buyer, the new buyer shall get better title if he acted in good faith without the notice of the defective title. So I've got the item, title has passed to me, but let's say you got a good deal and then you've sold it to someone else. Here, when I come back, I cannot go to the person who take the item. I would have to deal with you. When I'm dealing with you, I can now sue you. I can now sue you for what? Damages, and I can sue you for the price also. And then last but not least, we have sales by finders. So if I just find the goods, it sounds weird, but sometimes people can just find goods. So if they find goods, they can keep it for a number of years or a number of time, a reasonable time, and then they can announce. If no one comes for it, they can just sell the goods. So, for example, you live by the sea, and then someone's package washes by. It is just a package full of fish, a box of fish. The fish can get spoiled because fish are perishable. You try to keep it for a week, waiting for someone to come for it. The person doesn't come for it. You can just what sell the item. You just find the goods. You can just sell the item. Here we are saying that with the sales by finders goods, if you keep it for a reasonable time, and they make effort to reach the owner and they don't get the owner, you can just sell it. So sometimes if you just see someone's item and then the item is there, however, you are paying storage for the item. You are paying storage for the item. So yes, so you've paid storage for, let's say, a month, you've made an announcement, the person doesn't come. It is your money that you used to pay for the storage and for the announcement. So if the person doesn't come, you can just sell the item to what? Defray all the debt that you've encountered. Because you did your best, you tried to find a person, and then what, you couldn't find the person. The idea is that if you find a person, when the person comes, the person just what? Reimburse you, and then what? The person will take the goods. But if you cannot find a person, you can just what? Sell the goods. And if you sell the goods, the third party gets what? A better title of it. So you are saying that a buyer from a finder of goods who sells the goods would obtain a better title under the following circumstances. One, when a seller cannot be found after a reasonable diligence search, the keyword is what? A reasonable diligence search. Let me even highlight the reasonable, the reasonable diligence. That's what you did whatever possible. You did all announcement, you did whatever possible best to make sure that what you find the person, I couldn't find the person. So when the owner refuses to pay a reasonable and lawful charges of the finder, I have found the item. I have kept the item, and then what? The item is now what? In storage. I've paid for, let's say, a week amount of what? The item in storage. Pay me, reimburse me, and then what? I'll just give the goods to you. You don't want to pay me. I can sell the goods to what? Defer what? My debt that I incurred in the storage. So if you don't pay me a reasonable and lawful charges, you don't get your goods. I can resell it. Then lastly, when the goods are in danger of perishing or losing a greater value. So I find fish just washes by the shore. I find the fish. I keep it in the refrigerator for a month or two. You don't come. I'm incurring cost. The fish might go bad. You're not coming. I can just what? Sell it and what? Use it to defray my debt. And then the buyer would acquire a better title. So the idea of the Nemo that is that if something doesn't belong to you, you cannot sell it. However, we say that under these exceptions, when you sell it, the buyer would acquire full and rightful ownership under the following exception that I've just listed. All right, please, any questions? All right, so it is time. So this is what I'm going to do. I'm going to resend everything that we've done, slide by slide, with its acts on the page, so that it will help those who just join the page, and it will help everyone to Just go through. So I'm going to send from unit 1 to unit 6 with their corresponding acts. That is the first thing. And then I would send tutorial sets. These are not even exactly tutorial sets. They are just compilations of past questions. Compilations of past questions. So I'm just going to send you a compilation of past questions. Now, the past questions, most of the questions that you would see, you would be able to answer. For example, name exceptions and that the number that you will be able to answer. What is a good, like all of these things you'll be able to answer. But when it comes to the case study, that is where it requires some level of what understanding of how to solve a case study. Because with a case study, they will give you about 1 page. And then when they give you 1 page, a case study, then they'll ask you to what? Advise the parties. There are steps that you would have to take in order to what? Advise the parties. If you just advise the parties, you can get 1/10. But there are steps that you take to advise the parties. And I've always want students not to use their emotions to advise the parties. That's those kind of things. No. So I will send everything, and I will send a compilation of the past questions to you. Now, when I send a compilation of the past questions, there are a lot. Sometimes I don't even want to send it, but I want you to know how questions are being asked. So, and when it comes to the case studies, the questions will not only be case studies, but I'm just saying that those are the ones that you might not be able to handle them well. Those are not the ones that sometimes just reading it, you will not be able to handle it well. So maybe I'll need just an extra hour, even 30 minutes, just to show you the steps in solving the case study. That doesn't mean the questions will only be case study. No, it will be a mix of case studies, and it will be also be what is list, outline, those kind of things, and other forms. But the other forms, I'm confident that wherever we are in our lives, at least we should be able to answer those kind of things. That's all I'm saying. So I'll be sending all of these things, and then I'll need an hour. I don't know whether we can do it today or tomorrow, but I'll just need an hour for us to discuss. Now, generally, this is me inferring from previous cases. Generally, the quizzes, it is 20 objectives. Quiz 20 objectives, and the exams is usually 20 objectives. 4 questions section B, and then you would answer 2. Generally, that's how it is. So generally, we have quiz being OBJ 20, and then you have exams 20 objectives, 4 section Bs, you choose 2 questions. That is how generally it is. It can change. If you go and meet any different thing, don't go and mention my name. I'm just telling you how it has been for the past years. How it has been for the past years. And what again? So yeah. Yeah, so I think I've given you all the announcements. So let's decide. I just need like 30 minutes or an hour. We can even do it right now, depending on whether you have a class or not. 30 minutes or an hour, just to show you how to answer case study questions, and then we'll be done. 30 minutes or an hour, just to show you how to answer case study questions. So
Sir, please, let's find a day within the week and do it.
All right, within the week, okay, because we are in the Salah and then this one, I don't know what. Sometimes some people will complain that they are going to work.
No, if we like a day within the week, it will be evening time, not daytime.
Please, so it depends on you. Any day that
Monday is holiday, so we can use the Monday to do it. Or
all right, it's not even going to keep long. Just 30 minutes, 1 hour. But so let's decide on the time, and then you communicate to me. If there's anything else, I'll let you know. If there's anything else, I'll let you know. So without any further questions, we'll end here, and then I will send you the notes and then the past questions as well. All right. So if you have any questions later, you can just ask on the page, and then we might also try and then help each other with the questions.
Okay, thank you, sir.
All right. So without any further questions, we would end here.
Okay, sir. Thank you.
All right. Bye.